हाँ, 3-4 दिन ही लगे। जी जी। हाँ, तो आप ना काम स्पीड से कराओगे तो भी आपको 15 दिन लग जाएंगे, ये सारा कंप्लीट कराते। हाँ, जी जी जी।
my lord, without certified copy, my lord, appeal we allowed to file. I have applied for the certified copy.
Very urgent matter.
Yes, my lord. There is an extreme urgency. My lord, the urgency is that, my lord, celebrate the birthday of the Rabindranath Tagore. My lord, that is the issue in question. My lord, due to the political inference, my lord, the students, my lord, of the 3 colleges, they have been, my lord, stalled.
They have been prevented.
Prevented. Not only that, my lord, the issue remains that as the son of the minister of this assembly, he has not been made a convener. That is the issue. When I have annexed the document also. This is the urgency.
But your writ petition was dismissed.
No, it has been disposed of with the clarification to go back to the self-same person that who will clarify the same, why he will not allow.
And who appeared for the respondents?
My lord, appeared, my lord, state authorities, my lord, they have appeared on behalf of the state court. And
Advocate General appeared?
No, Advocate General has not appeared.
Then you please give notice to the State Council.
Lordship, I shall. I'm grateful.
My lord, earlier occasion another learned advocate did not appear. And unfortunately, my father expert, that is why I could not appear. Lordship, kindly give me leave.
My lord, another, my lord, indulgence. My lord, item number 681 of
but
the
upgradation, you please wait, sir. This side of the vacation, we don't know.
My lord,
very difficult. Please.
I am grateful.
My lord, may I have your lordship's leave under a compelling circumstances to mention a public interest litigation which I am moving in person. My lord, in that case, 22 lakhs candidates are involved of TET 2014, and this petition will only help to solve.
Why a public interest litigation? The student can come.
No, my lord. Here. I have given a solution and it has been heard by the.
You filed the matter.
I have filed already, my lord. It is appearing as item number 440 with other 2 matters which are not at all related, because my matter.
You give the mentioning slip. Let us see.
This is a matter in connection. My lord had hard batch of writ petition DVC matters, but my lord was pleased to allow restoration. But the restoration has not been done from 15th month. My lord, I have filed a contempt. My lord, I am more interested not in the contempt getting illicitly. 500 about 1500 workers are there. 15th March, my lord.
If you have filed the contempt, it will be
My
listed.
lord, I am opposing this particular matter, my lord. This particular matter wherein my learned friend is mentioning, my lord. In this particular matter, if my lord recalls, my lord, there is a specific direction that they are going to pay the usual charges and expenses. But in this particular matter, there is a security deposit shortfall. They are not paying the security deposit. They are not paying the security deposit.
They have a security deposit of 10 crores. They are asking for
another
10 crores. I'll show from.
All right, we'll see here.
Kindly, my lord, at the time of hearing,
Deeply obliged, my lord.
May I have the permission? Lordship, I have mentioned the matter yesterday, but Lordship has rejected it. My lord, I am in a dire need. After getting so many orders, several orders from the Honorable.
What is this matter?
Drug peddlers are getting inside.
What is the urgency?
Lordship, drug peddlers are getting inside our premises and they are attacking us.
If already High Court has passed an order in your favor,
Lordship, but
and there is a violation by the some police, etc., you file a contempt. We'll list the contempt.
Lordship, it's a appeal. I have made an appeal. It was running in the last month. Item number.
No, 2022. You please wait.
Under extreme compelling circumstances, my lord, may be permitted to mention, my lord, on matter on behalf of the added private opposite parties, my lord, whose, my lord, cooperative credit loan have been freezed because of this, my lord, pendency of this writ petition.
You filed a petition for
my lord, they are, my lord, there is interim order, even in spite of the respondents are, my lord, frozen the loan cooperative credit 175.
Then you file an application, a application for some interim relief. We will list that application.
Lordship, subject to if my lord.
No, we can't upgrade, sir. You file an application, we will hear.
As your lordship, please. Grateful, man.
Please come.
My lord, I am beseeching your lordship's benedictional indulgence for item number 621 of the main board. This is the contempt matter in respect of the your lordship's order of 19th of last month,
Despite your lordship's explicit and lucid order, the electricity connection has not been restored. Resultantly, more than 600 labor and other technical staff is lying hard, sitting idle, my lord. So normally I have been told, my lord, the contempt matter comes on Friday. Since Friday happens to be the public holiday, so I am praying, my lord, that it should be listed tomorrow at the top of the board, my lord, because there are
Please switch on your video.
video switch on.
No, somebody mentioned the matter just now. They appeared here. They said they have filed a contempt petition. We have granted permission to list the contempt petition.
I am praying at the top of the board because there are extenuating circumstances. Survival is difficult, my lord. This is the case of economic life and death.
Yes. Please call the list.
Appellate side, daily list, serial number 1.
Yes.
My lord, we had mentioned this matter, my lord.
And I am appearing for some of the applicants, my lord, students.
My lord, there are several applications in connection with a public interest litigation. Now, my lord, the matter pertains to, my lord, admission and, my lord, registration of DLED course. Diploma in Elementary Education.
So there is some interim order.
Yes. For the session 2021-23, my lord, the interim order is.
We deem it proper to restrain the respondent.
Yes.
West Bengal Board of Primary Education
Right.
from giving admission to DELED
Right.
non-enrolled students for the session 2021-23. Oh, this is that
This is that matter here.
that physical classes.
Yes.
Now we have attended
Now, my lord, if your
classes.
lordship may kindly have a look to, my lord,
Now, sir is appearing for the petitioner.
Yes.
But if suppose the board verifies,
I have no problem.
if it
The
verifies,
board verifies that they had attended the classes,
right.
they had took the admission in
right.
accordance with the procedure, the board may grant them.
Yes.
But Lord, this matter, my lord, kindly keep it pending as a, my lord, preventive measure so that the others cannot, my lord, get into this through this process. Let the board verify. I don't mind.
And in the meantime, my lord, we should be permitted to, after verification, my lord, the
If
exam,
registration comes, I have to-
registration, everything.
who appears for the board?
My lord, Mr. Banerjee.
You please verify, sir.
That's my submission on the last occasion also before lawsuit.
That is our suggestion also. Senior advocate has agreed.
Yes, certainly. Your Lordship.
We have heard so and so.
May I file our affidavit, my lord, to that extent? Your Lordship?
On 3rd of January 2023, an interim order was granted in this writ petition. The operative portion of the order reads as follows. Page number 3 of the order. Only this much. The interim order, next page. The interim order which was granted for a limited period was subsequently extended, subsequently ordered to continue by order dated 5th January 2023. The grievance expressed by the writ petitioners is that persons who have not attended classes and who do not have the requisite attendance should not be enrolled as students for giving admission to should not be given admission to DELED course.
For the session 2021-23.
Session 2021-2023. The students who are said to have undergone the course of study
Attended classes, everything.
are said to have attended classes, though at the relevant time, on account of the lockdown during the COVID pandemic, physical classes were dispensed with in several institutions and virtual classes were held. It is asserted by the respondent students that all of them have attended classes and the respective institutions have records to show that physical classes were held by those were conducted by those institutions and the students have attended. This fact this submission needs to be verified. And the appropriate authority to do so would be the West Bengal Board of Primary Education. Therefore, primary education. Mr. Bhattacharjee, learned senior advocate appearing for the writ petitioner, submitted that if proper verification is done and the students have been found to have attended classes, then there may not be any issue for the writ petitioners. Thus, considering the facts and circumstances, we direct the West Bengal Board of Primary Education to verify as to whether the respondent students / other students of other institutions had in fact attended physical classes during the relevant period. The institutions are directed to produce necessary records to establish the same. And upon verification, if it is found that those students have attended the classes, then those students may be granted admission to the DEL ED course.
The registration, not
Registration and examination.
online registration,
They-
admission.
They may be granted registration for the DEL ED course examination. Within bracket session 2021-2023. The verification process. Now, how you will verify unless they have to give those documents?
They have to submit all the papers to
The respondent institution, the institutions where the students have undergone the said to have undergone the course of study is directed to submit all records to the board within a week from date. Upon receipt of the records and documents, the board shall cause verification of the same. And if any additional particulars or information is required, the same shall be directed to be furnished by the respective institution. And upon being satisfied, the board shall permit registration of those candidates. Let the action taken report be filed before this court by the board on the next hearing date.
Registration আর পরীক্ষার ব্যাপারটা বলে দেবে?
6th June.
6th June.
Registration will be done only online. Only
Whatever.
Whatever is the procedure.
Whatever is the procedure.
Procedure.
Not only two things.
Examinations are declared, it should be permitted to appear.
Registration.
What is next?
So there are a host of addition of party applications and vacating applications. It will give the numbers. Your lordship may allow the addition of party applications.
No. Addition of party. Who will correct the cost title? Nothing doing.
Very good.
Let us be formally added.
No.
Produce the cost title.
No.
I have a submission. When are we going to address the Honorable new Chief Justice? Is it tomorrow or day after?
We don't know. In fact, I was late because of that.
Justice Bhattacharjee can enlighten us.
We wanted it tomorrow. It can't be done. Probably on 5th, but they say
5th is a holiday.
Governor, His Excellency is not available. Holiday.
Yes.
So he is not available on 4th, 5th, 6th.
Oh,
9.
9th is a holiday. 8 is one day.
let us begin the new week.
Let us.
Only one clarification, your lordship, kindly enable us immediately after completion of this exercise. The board is entitled empowered to hold the examination. Kindly record that.
Needless to state, after the verification exercise is completed by the board, in terms of the above direction, the examination schedule shall be notified and conducted. Next para.
Serial number 2.
Wait. There are several applications filed for addition of parties. Addition of parties. In the light of the above direction, we are of the view that it would be unnecessary to implead all those candidates because it is the institutions where the candidates had undergone the course of study to establish before the board that the candidates have undergone the course of study, have physically undergone the course of study. There may be cases where the students might not have approached this court by way of an application. Therefore, the direction has to be complied with by the institution by producing records, after which the board will cause verification. Therefore, for the present, the necessity to implead those candidates does not arise. With the above observation, all the applications stand disposed of.
Very.
Next,
We are grateful.
all can dispose. Remove all the can.
Material number 2. Yes, my lord, I am for the appellants, well, petitioners. Well, this is one of just one of teachers have approached before your lordship
Yes,
that one of these former vocational training centers. Now, my lord, there is no appointment in the post of vacant post, and due to acute shortage, my lord, students are suffering. Now, if your lordship kindly peruse, my lord, page 38. Page 38. An
Yes.
order was passed by this court, my lord, in a appeal matter.
if such is the case, if those vocational centers are still in existence, direct the respondent look into the matter, take necessary action, filling up the vacant posts so that vocational training centers are effectively
That's
effectively
that
rendering.
has not been, my lord, taken care of.
All right, whether it is still in existence.
Well, some that has to be, my lord, verified because there are, my lord, number of vocational training centers. My lord, these are all attached with the institutions, my lord, aided institutions, and my lord, there are some private institutions maybe. But my lord, we are concerned with the, my lord, aided institution where, my lord, courses are recognized by the
Sir,
technical education.
Suppose
Mine.
a policy decision is taken
Yes.
that the state will not fund the vocational training centers, they will not fill up the posts, or they will not sanction posts. We can't direct them to
No,
do it.
I am submitting this, my lord. Otherwise, my lord, this course will be closed. This is the, your lordship kindly remember, my lord, kindly see. For the higher secondary stream, there are 3 courses. One is, my lord, regular courses, humanities and science group. And there is also, my lord, vocational stream. That stream, my lord, will be collapsed. So, my lord, for that purpose, if, my lord, if it is found by the education department and the technical education department, if they sit together, they can, my lord, take a decision whether.
How from 2016, they are all lying vacant.
My lord.
From 2016, nothing has been done.
Nothing has been done. I am told, my lord, 2006, from 2011, my lord, posts are being, day by day, vacancies occurred. It is a policy decision, no doubt, but they will have to take a decision whether, my lord, vocational.
You take a decision. You take a decision.
Yes, sir.
You can take a decision, policy decision. See, vocational stream is also required.
Yes.
What are the various vocational
My
streams?
lord,
May I say this? This is not entirely correct
No.
in the sense.
well, sorry.
May I say this? I have with me today a notification in front of me, which is dated 30th September 2019. This is a notification for engagement of teachers, instructors in various
Vocational centers.
Yes, so Malad, it is not correct that from 2011 nothing has happened. Maybe there are vacancies. Malad, I am not over here disputing that position. But Malad, that no vacancy. But if there are at all, Malad, the government will take a decision.
By this writ petition, styled as a public interest litigation, the petitioner seeks for a direction upon the respondents to recruit teachers and instructors at vocational training centers of West Bengal by taking into consideration the direction issued by this court in WP 1643 within bracket W of 2016, dated 19/2/2016. The said order reads is as follows. Page 38, please extract. As could be seen from the above order, no positive direction was issued to the authorities, but they were directed to look into the matter and take necessary and suitable action in filling up of the vacant posts so that the vocational training centers are effectually rendering their training to the needy persons. A time frame was also fixed for the authorities to look into the matter. It is the grievance of the petitioner that the grievance of the petitioner is that till date nothing has happened and the vacancies continue to exist. So far as the aspect as to whether vocational training centers have to be established and whether contractual appointments or part-time instructors have to be appointed are all policy matters which have to be decided by the government, and no writ of mandamus can be issued to the government to enact a policy in a particular manner. However, considering the need for vocational training, all that we can do is to direct the authorities to take an informed decision in the matter. The petitioner has submitted various representations to the authorities, and those representations are stated to be pending. In the light of the above, the writ petition stands disposed of by directing the appropriate authority of the state of West Bengal to consider the grievances expressed by the petitioner and take an informed decision as to whether the recruitment to the posts of teachers and instructors at the vocational training centers of West Bengal is required to be filled up or to be manned by contractual or part-time teachers, etc. Such decision be taken by the appropriate authority within a period of 3 months from the date of receipt of the server copy of this. Next.
Serial number 3. My lord, may I take indulgence, my lord, in earlier matter with the item number 2. Directions has been given upon the respondent, state respondent, when specifically your lordship can direct one respondent 2 and 3. One is director, 2 and 3 and 4. One is principal secretary and director, 4 is director of vocational education.
Secretary Finance won't take that decision.
No,
It is go to the next level because
actually principal secretary, technical education, if there is
appropriate authority of the respondent
and also director, my lord, respondent number
such
4
as
particularly. He can supply the information
or the authority in charge of vocational training.
My lord, that will do. Vocational.
Yes. What is the next matter?
Next matter is, my lord, I am actually praying, my lord's uniform policy that why, my lord, but at page 27, my prayer B, lordship kindly look at page 31.
Let them they do that exercise which we have directed in item 2. For the present, you withdraw this writ petition and we'll await the decision.
My lord, I'm appearing for state in this matter. My lord, I'm appearing for state in this matter.
You're assisting.
He's assisting me.
Assisting me virtually.
He's anxious that perhaps I would not be able to reach your lordship.
So, in the light of the direction issue in WPA 189 of 2023, the petitioner seeks permission to withdraw this writ petition and renew the request, renew the prayer if a need arises at a later stage. Dismiss with withdrawn with the liberty as sought for. Next.
Serial number 4. My grateful.
Yes,
Lordship, in item number 4, I beg to appear on behalf of the petitioner.
Yes.
This, Lordship, may I file my affidavit of service?
Please.
Lordship, this public interest litigation has been filed seeking enforcement of a government scheme, namely the Jalodhara scheme.
What is that scheme?
I am coming to that, which was propagated in 2018, Lordship. By way of this scheme, Lordship, the government sought to introduce or rather finance the small scale entrepreneurs in the coastal areas of southern West Bengal.
Very good.
To modernize the ferry system. Lordship, due to the age-old ferries that ply in the southern fringes of West Bengal, Lordship, several accidents have occurred. Lordship, if my lord will kindly take up page 27, the scheme is annexed there.
Lord, there's a detailed representation at page 127 of your lordship's brief.
That can be considered.
Lordship, that will suffice.
127.
Yes.
By this writ petition, the petitioner seeks for petitioner, which is it's a trust, is it?
It is a
petitioner, which is it's a section 8 company. Please see page 127. A petitioner which is registered under section 8 of the Companies Act 2013 seeks for implementation of a scheme. Buttu Butti, yes.
What Buttis?
Buttu. called Butbuti, which is essentially BH.
No, this is onomatopoeic because that is the sound they make.
Oh, so like this Toto.
Yes.
Yes.
Butbuti, BHUTI, Butbuti, whereby the conventional ferries were to be motorized and made safer for the passengers to cross the river. The petitioner would state that immediate implementation of the scheme is required as the conventional ferries are unsafe. On many occasions, there is overloading and there are no life jackets, resulting in very many fatal accidents. In this regard, the petitioner has submitted a detailed representation on 24th February 2023. And the learned senior advocate appearing for the respondent state would submit that the third respondent,
yes,
the principal secretary transport department,
the third
may be
respondent is the
directed
district magistrate.
Directed to consider the said representation. In the light of this above, without going into the merits of the contentions raised by the petitioner, there will be a direction to the third respondent to consider the representation dated 24th February 2023. And if any information is required from the petitioner, the same can be called for, and thereafter an informed decision be taken by the fourth respondent. In accordance with the law, as expeditiously as possible, preferably within a period of 6 weeks from the date.
I'm great. I'm great.
Serial number 5.
No, transport department. No.
Because the notification is by the transport department.
Yes, Lord.
Fourth respondent.
Lord, fourth respondent is the district magistrate.
No,
The third respondent is the district magistrate. There's a disparity between the representation and Lord, the cause title. In the representation, it has changed, but
in
it
the
should be
cause
Lord,
title,
the respondent number
Fourth
4.
respondent is the principal
number
secretary
4 principal
transport
secretary.
department. Fourth respondent.
Yes.
Principal secretary transport department.
Next. Item 5.
I am for the Union of India. I'm led by Sri Billadal Bhattacharya. He's.
I am for the Milord petition. This is my affidavit of service, Milord. In the present case, Milord, the Union of India, Milord,
Commanding the respondent number 2. Who's respondent number 2? Assistant Commissioner, Department of Animal Husbandry, to file a report. Then commanding respondent number 5, Chief Executive Officer.
here, Milord, this
Regarding the receipt, what is
here is the scheme introduced by the Milord Union of India. Milord, in the year of 2000, National Project for Cattle and Buffalo Bridge Scheme. Milord, in that scheme, Milord, the fund has been given by the Milord Union of India. Your Lordship kindly, Milord, your Lordship kindly come, Milord, page initial, Milord, page annexure P2, page 19. Your Lordship may ask me the question, Milord, this annexure related, Milord, in the year 2014. Your Lordship may ask me the question, Milord, how, Milord, the petitioner come, Milord, 2023. Because, Milord, I have annexed one document in connection with the writ petition, Milord. From the writ petition, I gathered the information that support my case. Thereafter, Milord, I filed the writ petition, Milord. In the, Milord, annexure at page 19, the Milord Union of India, Milord, in reply to my RTI application, your Lordship kindly see the Milord, the training stipend, Milord, 10,000. Thereafter, Milord, 1,500 per month, and Milord equipment, Milord, 30,000, Milord. My specific case is Milord, Government of India, Milord, given the fund to the Government of West Bengal, Milord. Milord, but the fund given to the Government of West Bengal, they have not utilized the fund as per, Milord, the information given in page 19. They have said, Milord, the fund has been utilized and the, Milord, certificate given by the Government of India. But, Milord, the fund for the, Milord, Prani Bandhu, who are working as Prani Bandhu for cat and buffaloes, Milord, they are not given the, Milord, benefits. That is my specific case. Your Lordship kindly see.
Who has taken away the money?
But government will not, that will not, the government says will not who taken away the money, how the money had been even utilized. Well, you will also kindly see the page 20.
But according to the affidavit filed by the undersecretary,
This is in connection with another petition.
they say the scheme is closed in 2013-14.
Yes, scheme is closed. When this scheme was alive.
Yes, Mr. Bhattacharya, kindly come to page 23. What is the information supplied?
This is the information supplied by the government.
Says no fund has been provided.
That is my case, Milord. Your Lordship, then come, Milord, the affidavit, Milord, the annexure P3, Milord, page 21. The apartment of the undersecretary, Milord, your Lordship, kindly see, Milord, the page paragraph 6. That is my specific case, Milord. The government saying, the state government saying no fund has been given. The undersecretary of the state government of India says that, Milord, this is, Milord.
No, they say the state has utilized the released amount of so and so lakhs, submitted utilization certificate.
Yes, Milord, utilize.
Who is the writ petitioner?
Writ petitioner is the Prani Bandhu.
Prani Bandhu.
Yes, Milord, the utilization would be, Milord, as per Milord annexure P2. You will have to kindly see what would be the utilization. Training purpose, the Prani Bandhu has to be given, Milord, for training purpose 10,000. Thereafter, Milord, stipend 105,000 per month. Nobody 3,000 Prani Bandhu working, Milord, in the Milord government of West Bengal, in the Milord state of West Bengal, Milord. No one get the benefit of this scheme as directed by the government of India. Not only that, Milord, the Prani Bandhu, instead of giving the benefit, the 5,000 rupees has been taken from the Prani Bandhu, Milord. That is annexed P1, page 18.
Yeah, 5,000 rupees they have given receipt.
Yes, 5,000 they have given receipt, Milord. We are not supposed to pay any amount, Milord, as per the government of India scheme. But we are, as per the government of India scheme, Milord, we suppose we are getting, Milord, we has to get the, Milord, the stipend money and the money for, Milord, training. But no amount has been given to the Prani Bandhu. Instead of that, 5,000 rupees has been taken. Not only that, Milord, the government of India specifically state in connection with another petition, Milord, the amount has been given. And the information supplied by the government of West Bengal, they have said no amount has been given, only 36 lakhs, and thereafter, Milord, 86 lakhs. But my respective submission before your Lordship, later report filed by the one of Union of India, Milord, the respondent number 2, because the state government saying that the fund has been utilized and the certificate has been issued by the, Milord, central government.
He's given some representation.
Not only that, Milord, in the page 27, Milord, the queries, Milord, put by the Justice Milord Bhattacharya, Milord, that, Milord, the amount, Milord, given by the, Milord, central government, and they are saying, the state government saying, Milord, utilized certificate duly accepted by the government of India.
Yes.
Fund has been given. Fund has been given. Now they are saying, Milord, we have utilized.
No, this page 18 receipt you are referring to. For what purpose? It says amount for AI equipments of Prani Bandhu 2.
Yes, AI
GP.
AI equipment request, Milord, for the training purpose. For that reason, Milord, the government of India, Milord, page 19 says in for training 10,000 rupees, including stipend.
See, you pick up some information 2014.
But that's why, Milord, I have stated initially, Milord, I have stated before your Lordship, Milord, that
no, this is a stale claim, Mr. Bhattacharya. 2003, this receipt, one receipt you have got for 5,000. Why this man? He is the writ petitioner.
Yes.
And why he has paid this 5,000, we don't know. Then immediately you jump over to a 2014 RTA query.
RTI, Milord, information, I had get 2014, Milord. I have specifically, Milord, in the, Milord, initiation, I said, Milord, the information I gathered, Milord, supporting my claim, Milord, from the, Milord,
no, it can't be a PIL. Prabir Kumar Roy He himself is a beneficiary or he has paid some money.
Beneficiary, he is not claiming for his benefit. He is stating.
Why did he pay this 5,000?
Because the government has asked for training purpose. That's why they have paid.
Where is stated so in your affidavit?
That is annexed P1.
No. In your affidavit, what is your averment? I paid it for this purpose. I thought it is for training, but the government has given so much of crores of money. They should not have collected that 5,000. And that fellow paid it in 2003 and 2023 you have filed it.
My respectful submission before Lordship.
It is absolutely stale claim. And you have not approached the authorities. This has been collected by the block level development officer. He is the lowest rung officer in the department.
That is government hierarchy.
You should have complained at the appropriate time.
Your Lordship kindly give me leave to submit one comprehensive replanation before the Union of India.
You first go before the fourth respondent or the fifth respondent.
My Lord.
He has to go say that, but those fellows who would have been retired and gone, who collected what?
Retired
is your instructions.
Lord, if your Lordship please comes to page 21. And Lord, please come to Lord paragraph 5 at page 21.
Yes.
Lord, please see the third last line. No funds were made available to the state for implementation of scheme after 2013-14.
Exactly.
So Lord, whatever has happened more than a decade ago. Now Lord, please come to the next paragraph. Lord, year-wise release of funds is tabulated up to 2013-14, which is the last annual year. Then Lord, please come very important to page 22, paragraph 7. State has utilized the release funds of such and such and submitted utilization certificates to the Department of Animal Husbandry, Dairy and Fisheries. Not to the central government department from whom under whose scheme it's being run. We have submitted all necessary documents before them. No question has been asked.
No, actually, in fact, he tried somebody else, Haran Chandra Das and others, filed the writ petition 2014. What happened to the writ petition? Suddenly he wakes up one day after 20 years and says, yes, I am Prani Bandhu. 5,000 rupees they have taken from me in 2000.
The utilization certificates are annexed to R1.
Yes,
R1 is not there in your Lordship. That has been left out.
Your client got these papers from somewhere, and it is your ingenuity and your research and your work you made it into a writ petition.
No, the question before your Lordship.
All right, we have heard Mr. Soman Bhattacharjee and an advocate, etc., etc. By this writ petition, the petitioner seeks for various directions in respect of a scheme formulated by the Government of India called National Program for Buffalo Breeding and Dairying Development, within bracket NPBBDD. The case of the appellant, primarily not appellant, sir, petitioner, rests upon a receipt given by the Paschim Banga Go Samad Sampad Bikash Sanstha, dated 4th February 2003, which shows that that rupees 5,000 has been collected from the petitioner. It is not known as to why the petitioner had paid the said money. And there is no specific government.
That is paragraph 10 I have stated.
The petitioner would then place reliance on an affidavit filed by the Undersecretary, Department of Animal Husbandry, Dairying and Fisheries, Government of India, in a writ petition filed before this court in WP number 326 within bracket W of 2014. This affidavit is pressed into service to show that funds were allotted to the state government by the central government. Thereafter, the petitioner places reliance on an information furnished by the State Public Information Officer, PBGSBS, to certain queries which have been raised by the petitioner under the Right to Information Act. By comparing the averments made in the affidavit filed in the said writ petition by the Government of India, on behalf of the Government of India, and the information furnished under the RTA Act, the petitioner's case is that funds have been sanctioned and no money should have been collected from the petitioner. In our in our view, the case as projected by the petitioner is a stale claim, and the petitioner seeks to place reliance on a receipt which was issued in the year 2003, collecting rupees 5,000 of the petitioner. In any event, from the averments made in the affidavit filed by the Government of India in WP number 326 within bracket W of 2014, it is seen that no funds were made available to the state government for implementation of the scheme after 2013-14. Further, the affidavit states that the state has utilized the release amount of rupees 7508.45 lakhs and submitted utilization certificate to the Department of Animal Husbandry, Dairying and Fisheries. The copies of the sanction order and the utilization certificate received from the state were annexed to the said affidavit, which are not forming part of the present writ petition. In any event, the petitioner, without even approaching the concerned authority of the state government, has filed the writ petition seeking for an inquiry and other directions against a central investigation agency, which cannot be entertained. Therefore, no direction as sought for in the writ petition can be granted at this juncture. However, it is well open to the petitioner to approach the concerned authority of the state government who was in charge of the scheme and place facts before the authority, which shall be considered if considered by the authority if adequate facts are placed by the writ petitioner. With the above observation, writ petition disposed of. Next.
Serial number 6.
Your Lordship, kindly frame a time frame below because we have to
First you
There is
ask
no
him to
representation now.
go home, collect all the old records, then we will see. Ajay Kumar De.
My lord, I am for the petitioner.
Very good.
My lord, the service is not complete. That is one aspect.
Pardon, sir, service.
Service. Now, Lordship, there is a reason why service has not been completed yet. Lordship, kindly peruse these documents which have been handed over to me by the client. That after filing this, he has been threatened by some of the local people. The issue involved here is the revival of a cooperative bank, which is known as Ramakrishnapur Cooperative Bank. Now, this matter was going on in this High Court for a long time. A committee was constituted by the High Court.
Then you do one thing. You serve notice, we will take it up tomorrow day after.
Lordship, Ramakrishnapur Cooperative Bank, I know the advocates, and
there are other government authorities also.
Lordship, kindly give me 1 day time so that I can serve and come.
Please.
Because there is an observation. I have filed this in pursuance to the leave granted by a coordinate division bench of this court.
Very good, no problem.
Where I have brought some.
We'll fix it on Monday, 8th.
Monday.
The learned advocate for the petitioner shall serve notices on the respondent and filed affidavit of service.
Lordship, in the meantime, if petitioner is threatened, he will approach the police further.
You got lot of forum. You advise your client. List on 8 in the same position.
Lordship.
Serial number 7.
I appear for the petitioner, my lord. This is a PIL, my lord, where lordship has granted us leave considering the urgency, my lord. I have served on all of them, my lord, through electronic mail, my lord. The petition.
Who appears for the state?
Served all of them, but I find nobody appearing, my lord. It's a very.
Where is the affidavit of service has been?
Yes, my lord. I have filed, my lord, the.
Through email.
Yes, my lord. Since there was urgency, lordship granted us leave, my lord, and so we have filed it through email.
But at least you could have informed.
Because yesterday the government pleader's office was closed.
Oh, yes, May Day.
Court was working, but government pleader's office was closed, my lord.
Then you at least serve a copy in the government pleader's office today. We'll take it up tomorrow.
Very well, my lord. Kindly, my lord, if your lordship, my lord, takes it up tomorrow, my lord, at the first sitting, my lord. Because it's a very serious issue. Even after filing, the petitioner was arrested because he's filed this. He had to take bail at 2 o'clock at night, my lord.
And what is the problem here?
My lord, this is an my lord, incident, my lord, which would be, my lord, I would, my lord, rather, my lord, term it, my lord, as the incident which happened in America with George Floyd, my lord. Just because somebody, my lord,
No, this is that
the person who was, my lord, shot dead by the police.
that Kaliaganj incident.
Yes,
But
not
is-
the lady, not the lady, my lord, lordship. That's a separate issue altogether.
then-
That's pending before my lord. This is the incident where the person, my lord,
No,
was.
yesterday we disposed of a writ petition
Yes, my lord.
as a public interest litigation.
Yes, my lord.
Giving permission to them to intervene in the proceedings, which is now pending before the single bench, wherein directions have been issued, some to the central agency, etc. Several directions issued. And the petitioner was the mother of the victim girl.
Yes, yes,
And
yes.
we will grant you the same liberty. See, parallelly one.
My lord, I don't want so much, my lord. I don't want only two reliefs. One is that, my lord, the national commission should be allowed, even if the state commission is there to intervene,
sir.
to intervene.
No, no.
And the other, my lord, is for central forces. Because every day this is happening.
No, same prayer.
But I'll consider that, my lord, and see to it, my lord, and
the
come back.
petitioner seeks for direction upon the authorities to the petitioner who's who belongs to a petitioner who's a medical practitioner and belongs to a stated to belong to a political party, seeks for a direction upon the respondents to conduct an inquiry and trial into the incident of an alleged brutal murder of the victim, and to direct the central agents, direct the National Human Rights Commission and the National Commission for Protection of Child Rights and the National Commission for Scheduled Castes and the National Commission, Women Commission to conduct field inquiry and investigate into the alleged murder of the victim. In respect of the same incident, already a writ petition is pending before the learned single bench at the instance of.
My lord, this incident, it's not pending, my lord.
Yes, it is.
No, it is with regard to that girl, not with this incident, my lord.
No, this is also relatable to that.
No, this is a separate incident which has happened on 28, my lord. This has got nothing to do with that girl.
But dragging the body, etc.
That is, my lord, an incident which had happened prior to at the same place, which lordships have dealt with and passed an order yesterday as it fell from my lord. This, my lord, is a separate incident. My lord, in view of that, there were huge police searches made and, my lord, arrests made. This person was in the house, he was dragged out and shot dead. It's just like the Floyd incident in America. That is what, my lord, I would ask for two prayers, prayer E and, my lord, prayer G8. My lord, that's at page 16. Under 355, Article 355. This is a separate issue.
Then you do one thing, strike off that.
Yes, I would serve.
You serve. The learned advocate for the respondent is directed to serve the government pleader and the standing counsel for the respondents. Let the matter be listed. Then let it come on Monday. Monday.
But it would
because tomorrow is a residuary day.
Oh. But then on Monday, may it be, my lord, at least at the
Yes, Monday, same position.
Grateful, my lord. Deeply.
Next.
Serial number 8.
Notice there.
Yes.
My lord, further notice has been given, my lord. Even
my lord, just now I called the CBI lawyer, my lord, the Amojit there. He's saying, my lord, I know the item number 8. I will appear.
Lordship,
not here.
Mr. Amajit is engaged in a matter before court number 20.
But at least somebody can come and represent, no? We have been adjourning the matter, trying to find out who is the standing counsel. And if your senior is representing a central agency and they should.
He is prepared.
Pardon?
He is prepared, Lordship. He is engaged in a matter.
the only thing your lordship will kindly appreciate. My lord, the
All right, pass over.
Pass over.
I'm grateful.
Serial number 9. I appear to the Union of India.
My lord, earlier occasion directed on 3rd of April of your lordship office to circulate the report of the committee by 4th of April 2023.
Farmers suicide.
Farmer suicide. My lord, that report has not yet been circulated to me. I don't know whether state has got it or a report of the your lordship directed your lordship's office to circulate the report of the committee which was constituted by this honorable court on
No, you are referring to the 3rd April order.
3rd April order. Last portion, your lordship kindly see.
But that is my fault. I have to contact the office of the your lordship Today I will take the I have not got it because I have not contacted.
Because we have not yet got it.
But the copy of the report, if you can serve, he'll be able to assist the.
I don't have the copies, I have to collect the copies from the office.
Also, they have not served.
Another thing is, your lordships, another direction was that to state to reconstitute another But as I will collect the copies of this the committee
We'll give some time to the government.
Yes,
At the request of the learned advocate appearing for the state, let the matter be listed on so and so date. And by then, the directions issued in the order dated 3rd April 2023 shall be complied with.
Serial number 10.
Matter will appear, my lord,
6 June.
after vacation, my lord. Matter will appear after
Yes,
vacation.
after vacation.
My lord,
Yes, yes.
after vacation.
6 June.
My lord.
Yes,
Item number 8, my lord. Sorry.
1 second. Item 10 is
Yes,
called.
Lord.
I beg to appear on the petition. What is item 10?
Number 7, my lord. I'm paying short pass over my senior my lord in the
This was
court
item
number.
223 in the monthly list.
But
No
whatever.
notice was given to us that it
No, it has come automatically. Yesterday,
Yes.
people are mentioning for upgradation what to do.
But
Let me the short
unless
pass over. my lord.
notified, it's very
But this is a case, land.
Of the notice prior to mentioning.
So I did not mention the matter. It come
Yes,
automatically.
yes, yes. Yes, come up
No,
on mentioning.
sorry, come up on mention.
So
Yes.
let it go out of the list.
Notice this? You passed it on.
Ashul,
No notice happens.
What is this thing? You call
this
it.
matter was upgraded upon being mentioned by the learned advocate for the petitioner.
What is this?
However, no notice of mentioning was served upon the respondents or the learned advocates representing the respondents.
What is that?
To stop. In view thereof, let this matter go out of the list with liberty to mention after 4 weeks.
Call the passover matter.
Serial number 8.
Lordship, I tender my unconditional.
We have been eagerly waiting for how many times adjourning, who's appearing for CBI, who's appearing for CBI.
Lordship, yesterday notice, written notice was served.
Earlier also I have served notice. All right, doesn't
Earlier
matter.
asked for a
Oh,
liquidation.
what is your instruction? You are supposed to, rather CBI is supposed to file a status report. Where is the status report?
Lordship,
Matter is running from 2011.
Lordship, I will take instruction. I will submit a report.
When-
Kindly give me a fortnight's time.
May I
Time,
submit, my lord?
And in the meantime,
My lord,
Lordship, let
you
him
kindly
serve a
consider
fresh
this
copy
is a
upon me.
response under RTI.
Your friend does not have papers. He does not have any instruction. He's come into the brief only now.
Lordship, I have
He is
put him in
ignorance
receipt
of
the
any
brief.
of the orders.
Brief, he was briefed earlier. It's not that much.
Lordship,
He
no,
is
no, no.
coming to
These
know
are-
us now.
These are all the order sheet,
Yes.
orders, bunch of orders.
Yes,
More
ma'am.
than 50 orders have been passed from 2011.
But only
Maybe there
difficulty,
are
your
actual
lordship,
advocates there.
kindly, there.
Let him serve a copy and
Only
allow me.
difficulty, your lordship.
Which you don't have copies.
No, Lordship, I don't have the copies.
And what happened to the copies given to your predecessor?
Lordship,
At least the department should have the file and give it to you.
that's true. That's true.
And how he will make out a photocopy of the entire bunch? It will run to several thousands of rupees.
My lord, the only thing, my lord, your
The
lordship,
repetition
remember, my lord, in this incident, there was a direction for interim compensation. Then it was ultimately finalized. The state government has made the payment of the compensation. That part is over. The part remain is, my lord, the trial. My lord, for last 12 months, my lord, the under the monitoring of this honorable court, my lord, this trial is being conducted.
for last 12 years, 4 months. My lord, I'm told, my lord, on the basis of the RTI, and the answer given 26 witnesses were, my lord, examined.
Out of 115.
Out of 115. Now, your lordship kindly appreciate, because of delay in trial, the principal accused has, my lord, got bail. Now, he is, my lord, showing his old form. Old form, the principal accused. Your lordship kindly read, my lord, the order dated 11th February 2011. For a moment, my lord.
18 February.
18 February, I'm stand corrected, man. Kindly peruse.
Yes.
Kindly see, my lord, after 3 pages, my lord. The ruling political party who was there, my lord, they have been named, even it is something, my lord, unnatural, my lord, what this has happened. And my lord may remember, this was an all India news that the Honorable Governor, my lord, gave a statement to this effect after this incident. And on the basis of the papers, my lord, it was taken up.
9% was killed.
9 persons were brutally killed, my lord, by police, by firing, with the active association of the local political party, the Indian ruling political party. Now, your lordship kindly make a simple arithmetic calculation. If in 12 years, 4 months, only 26 witnesses have been examined, how long it will take, my lord, to examine 115 witnesses? Whether anyone will remain, whether the persons who are the victims, they are crying for justice, they will get any justice at all or not.
Yeah. So the trial
Compensation is not the factor.
Trial is pending before which court?
Before the special court, my lord.
Paschim
Midnapur. West Midnapur.
What is the case number?
Case number.
I'm just giving, my lord.
No, PS case number আছে।
এখানে এটা দেবে। ওইটা কোথায় যায়? তুমি দিয়ে দিও না। এটা দে আমাকে, RTI টা দে।
RTI টা।
মানে RC3S by
এটা দিয়ে দিন।
Wait. RC?
Well, I'm giving just my lord.
This is the RTI copy.
RC, CBI.
Special court?
Judgment को रहा है। It will be just right side.
Are you sure about the court, special court?
Yes.
Huh?
Lordship,
Because we intend calling for a report from the court.
Yes, my lord.
If you give the if you don't give the correct court, then it will be a problem.
This is West Midnapur, my lord. Because the
Lalgod PS.
Lalgod PS, my lord, and it is under West Midnapur.
You please write down.
Yes.
Lalgod.
And you furnish one copy. You
Yes.
take photocopy of your.
Lordship, in the bail matters of this particular case, Lordship, I appeared for the CBI. And, so far, my knowledge goes, out of probably 14 accused, 11 has been granted bail and 3 persons has been rejected. 1 person has been granted bail from the Honorable Apex. Thereafter, subsequently, this and
if I number
as per order of my lord, division bench presided over my lord
Lalgod PS case number.
Trial has been expeditiously proceeded.
Lalgod PS case number.
Probably 29 witnesses has been examined.
Oh, so that matter is still pending before.
Lalgod PS case
29
number.
out of 100.
No, whether the matter is pending before the other division bench.
No, Lordship.
At the
It
time
has
of
connection with the bail petition.
at the time of
No, your learned friend says
at the time
direction has been issued by the division bench.
Yes,
That
Lordship.
is in connection with the bail application.
Yes,
my
so
lord.
to proceed trial in day-to-day basis.
Maybe, sir, the submission is direction has been issued to expedite the trial. So we can't be issuing parallel direction. So the judge will get confused. And you are a bar association writ petition. And that is a case concerning the accused, which has got more value. It has got more value. You first produce that order.
Lordship, kindly take it at 2 PM. I will
2
produce
PM
order.
today we can't take. Today is original appellate. Huh? All right, pass over. You get that order.
Lordship,
You
Lordship,
give
I will-
copy of that order to your friend.
এটা দিয়েছো এটা এই যে
তাহলে এটা দরকার নেই এখন। দুটোর সময় নিয়ে আসবো, কপিটা নিয়ে ওটা সব দিকে ভালো।
Serial number 11.
এটা দেখি
Lordship 11, I am for the petition, Your Lordship. Lordship, this matter is pertaining to misuse of public fund in the name of constructing road under Pradhan Mantri Gram Awas Yojana. Lordship, there are three discrepancies. One is when the tender amount is more than 5 lakhs, it's generally done through e-tender. Lordship, here the same project has been made into several projects, and it has been shown as less than 5, and e-tender has been bypassed. By doing that, Your Lordship, the wife of the Shevaputi, Panchayat Shabapati, has been given that tender. Now, Your Lordship, it is stated that within 30 days, the construction has to be done. The tender mentions within 30 days, Your Lordship, the construction was not at all commenced. After that, on 15th July, they have initiated the construction, but nothing has been done yet. It's still incomplete. But the money has totally been transferred to that jetty construction. Your Lordship, now to transfer the
Now,
money,
what happened that FIR was registered?
FIR was registered, nothing has been done yet. Lordship, on the last occasion, the respondent number 9 was asked to come up with instruction whether anything has been completed or not, Your Lordship.
No, the complainant there is
Yes.
one Shibiri Mondal.
Yeah, Shibu Mondal. Your
Shibu Mondal.
Yes.
Who's the writ petitioner?
Shibu Mondal is a writ petitioner.
And if suppose no action had been taken,
Hmm.
he could have filed for a direction under 482, or for before the magistrate you could have gone.
Your Lordship, it is not only about that FIR, it's totally about now the monsoon season is also coming. The entire public fund is at stake. Nothing has been done.
Any instructions you have got?
Yes, Lord, I've got instructions from the concerned Gram Panchayat. Lord, there were 14 items of work. These are really drains abutting the road. Drainage system, Lord, with regard to road. Of the 14 items of work, I am told, Lord, according to my instructions, that 5 items have been completed. And of the 5 of these completed 5 items, payment has been made to the contractor. Lord, the balance 14 items of work, they had been
11 items.
Lord, I'm sorry.
11 items.
11 items, Lord, work had commenced, but due to protest by the villagers because of the sighters of the work affecting, Lord, their movements, Lord, that the work has, Lord, for a time being, Lord, could not be
You
completed.
have shelved the contract.
No, Lord, it has not been shelved, but not for the time being because of the Lord, interference by the local people. It
Their
could not be
allegation
completed.
is tender has been granted or work has been allotted to the wife of some Pradhan
Yes,
or
Your Lordship.
somebody.
And also the main point is, Your Lordship, the total money has been transferred. If the BDO does not give in the completion certificate, the money won't be transferred. Then on the basis of what such completion
But how,
certificate has been
is it
given?
a fact that payments have already been made?
Payments have been made, Lord, my instructions are payments have been made in respect of 5 completed items of work.
For the remaining 11, you shouldn't make payments.
Lordship will make an observation, certainly.
No, you should
Lord,
not make
except
payments.
proportionate to the value of the work done.
That's true. But they question the very allotment of the work itself.
But Lordship, they have to come up with specific instruction which of the projects have been completed. My point is regarding from 11 to 14. Such construction is not at
But
all complete.
some other superior authority, can he not inquire into it? If the
Yes, Your
wife of the Pradhan gets the contract
Certainly.
and they want some CID, Superintendent of Police.
Lord, perhaps we do not need to go to the law enforcement agencies. At the administrative level, it can be done.
No, will you be satisfied if the district magistrates inquires into the matter?
Yes, Your Lordship.
Huh?
Yes, Your Lordship.
And we will dispose of the writ petition, the direction that if any money has been paid
Yes, Your
in
Lordship.
respect of the 11 works which has not been completed, it should be recovered. And if at all the work has to be reallotted, the whatever is the process notified by the government should be followed.
Lordship, may the petition be kept pending till the district magistrate reports comes up, Your Lordship, because once it is disposed of, they will delay the inspection. Only one day it may be kept.
From-
Reasonable time may be given, Your
You
Lordship.
filed the writ petition in September 2022.
Yes, Your Lordship.
Nothing has happened till now.
Lordship, only the instruction was sought for.
Nothing has happened. So today at least we dispose of, issue a direction. Let us set the ball rolling. We'll see.
Lordship, in such a case, may another direction may be given that payment that has already been, that should be kept or secured or maybe kept as a
By
fixed
this
deposit,
writ
Your Lordship.
petition, the petitioner alleges various irregularities committed by the 9th respondent in respect of implementation of a drainage scheme. The first ground of challenge is by contending that in terms of the notification issued by the state government, if the value of the work is rupees 5 lakhs and more, e-tender process has to be mandatorily followed. The further allegation is that the wife of the Pradhan of the ninth respondent has been allotted certain works which have been done without inviting the e-tender process. Further, it is alleged that payments have been made to the contractors even before the work could be commenced and completed. And therefore, the appellant prays for a full-fledged inquiry. The not appellant, sir, petitioner. The petitioner has also filed a complaint before the Ranaghat police station, which has been registered as FAR number 546 of 2022 for alleged offences under section 420, 409 and 34 IPC, dated 28th February 2022, 28th July 2022. However, it is stated that till date, no action had been taken by the said police. The learned senior advocate appearing for the respondent state on instruction submitted that totally 14 items of work were given to various contractors, of which 5 items of work has been completed and payment has been released. With regard to the balance of 11 items of work, though contractors were nominated, though contract was awarded, the contractors could not complete the work on account of protest by the local villagers, with the villagers raising several issues. The allegation that e-tender process was not adopted, and that the kith and kin of the Pradhan of the Gram Panchayat has been allotted the works, if proved, is a serious matter. Though the writ petition has been pending since September 2022, till date, nothing appreciable has happened in the matter. And therefore, we are of the view that instead of keeping the writ petition pending, a direction can be issued to the district magistrate Nadia to conduct a full-fledged inquiry into the matter, so as to ascertain as to whether any fraud or misappropriation of public funds had taken place. In the light of the above, the writ petition stands disposed of with the direction to the second respondent to conduct a full-fledged inquiry into the matter, including as to whether the proper tendering process was followed by the authorities before, followed by the Pradhan before allotting the works, whether the 5 works for which payments have been made have been completed to the requisite satisfaction of the authorities, and in respect of the remaining 11 works, direction can be issued to the Pradhan not to release any monies, and if monies have been released and no work has been carried out, the respective contractors may be directed to refund the amounts paid to them, and the district magistrate shall issue necessary directions as to how in future the allotment in respect of the 11 items of work should be done. The above direction be complied with within a period of 4 weeks from the date of receipt of the server copy of this.
Lordship, only one correction.
Needless to state that the above direction be complied with after issuing notice to the 10th respondent.
Lordship, on one correction, it will be the wife of Shobhapati, not Pradhan.
Oh, wife of?
Wife of Shobhapati. Shobhapati. Wife, not Pradhan.
Shobhapati.
And
next to the Pradhan.
Lordship, may a copy of report also be served to the petitioner?
The petitioner shall also be kept informed of the outcome of the proceedings. Next.
Deeply obliged.
Serial number 12.
My lord, I am for the petitioner, my lord. This is a case, my lord, where 4 persons were picked up by the police within a period of 10 days. They were in custody. All of them were found dead. My lord, would kindly come to my petition, page 23, my lord. My lord, of the 4 persons, 2 persons PM report we have been able to get hold of. Kindly comes to page 23, my lord.
Yes.
My lord, kindly sees there are 26 injuries in the middle portion. That 4 lines from the bottom before the membrane, 26 injuries in the body. Kindly comes to the next page, my lord.
1 second. Which 23? Is something different.
WP number 594.
There are no annexures to it.
My lord has got it, my lord?
Yes.
Yes. Kindly sees in page 23, there are 26 injuries just before the scalp, skull and vertebra. 4 lines just above that, 26 injuries. My lord, kindly comes to the next page. My lord, the next page is the PM report of another person. My lord, here just at the bottom, remarks by civil, right bottom, remarks by civil sergeant. Just a few lines before that, 39 injuries. Just a few lines above that. Remarks by civil surgeon, just a bit about 39 injuries. So in police custody, my lord, the learned friend from the state will be able to supply the other 2 post-mortem reports. Kindly sees the nature of injury in all 4. My lord, the matter on the day it was first taken up, the learned advocate general appeared and assured the court that they will look into the matter very seriously. Thereafter, my learned friend filed an affidavit along and made a prayer that another affidavit will be submitted before the court. Till date, that has not been done. There is no investigation going on, and I reasonably suspect, my lord, the police and the state are hand in gloves, and they are going to completely remove all evidence. And these 4 persons whose right under Article 21 has been violated will not get justice. And my lord, my learned friend has submitted one affidavit. My lord, kindly takes up that affidavit.
That's what we are reading.
Yes. My lord, kindly sees in that affidavit, it has been stated, same thing has been stated about all of them, that they were drug addicts.
But there is nothing to show how these people sustained those injuries.
Nothing to show how this. So in the event of arrest, my lord knows, in view of DK Basu and other judgments, there has to be a medical examination. A medical report has to be there. Thereafter, they have to be taken into custody. And every injury has to be explained.
And what is the prayer in the writ petition?
My lord, we have prayed for a CBI inquiry because we have we reasonably believe that the state will not investigate this properly. And my lord, the compensation. It is very interesting, my lord, that soon thereafter, 3 lakh rupees each was handed over to the family members to shut their mouth. And that is it. That is all.
Yes,
My lord, after the death, my lord, death was occurred undisputedly, my lord. After the death, my lord, there is a, my lord, inquest has been done before the my lord, executive magistrate. Then my lord, a judicial inquiry my lord, ordered by the my lord, by the chief judicial magistrate because to the my lord, gravity of the matter. That is also done. My lord. I can my lord, bring. I till date my lord, not
Nothing
got-
has happened. See,
my lord,
death occurred.
these are all, my lord, the
in
judicial interventions was there.
July 2022.
But I know, my lord, the judicial interventions was there. My lord, there's a four, my lord, the judges that my lord, appointed.
See,
My
what
lord,
you should have done is, if you really, as per the earlier orders, what was undertaken
sir.
by the court, if you are very serious, you would have handed the matter to the CID at least.
But-
Constituted a special team, because you are going to go into whether any excesses were committed inside the correctional home. And you shouldn't be saving your own officers.
No, no.
Then-
That should not be, my lord. I am not here, my lord, your lordship,
And
because I am
nothing
not
has
here, my lord,
progressed till now.
to save
That's
out
the-
the, my lord, the any adding officers, my lord. I'm not here to, my lord. My lord, your lordship, my lord, so direct, my lord, we will, my lord, investigate and come back to your lordship, my
Not
lord.
now, after, it's going to be a year now.
My lord,
1 year, nothing
kindly
is
take our report only, my lord, on 16 January, my lord, we have filed a report, my lord. 16th of January, my lord, we
Yes, I
filed a
saw
report,
that
my lord.
report. That report
My lord,
is neither here nor there.
well, there are two parts. One is, my lord, the compensation parts. One is, my lord, the invested into the deaths of the, my lord, the persons, my lord.
16th January 2023 report does not take you anywhere. It
But,
just says what happened. It is actually all, details from the postmortem report has been gathered and set out as an update. That's it.
My lord, kindly take, my lord, the paragraph 7, my lord.
And who will appear for CBA?
No, CBI is not appearing, my lord. CBI is not a party, my lord.
CBA is not a party.
No.
Then, but you have prayed for that.
My lord, if your sole lordship so desires, I'll make CBI a party.
No, why we should desire? It's up to the
My lord,
dominus letters.
my lord, we'll amend
He
the
has to
cost.
know whether
My lord,
who has to be made.
may I submit one thing, my lord?
Well, we'll amend the
My lord,
cost title and make
give us,
CBI.
my lord, the 4 weeks time, and my lord, direct the, my lord, CID to, my lord,
That
file
will
a
be
report
better.
before a lordship, my lord.
Let the
File the, my
CID
lord,
do it for now.
file a
lord,
report before
my
a
lord,
lordship, my lord.
my only prayer, my lord, my lord has understood, my lord, what the situation is. My lord, my only prayer is that let this be under the supervision of this honorable court, my lord.
And
lordship,
come back to your lordship. We'll come back to your lordship, my lord. After the CID, my lord,
my
investigate,
lord,
we'll
and
come
my lord
back.
kindly directs the matter to specifically appear, my lord.
This
Otherwise,
petition filed as a public interest litigation by an association seeks for registration of a case under the appropriate provisions of the Indian Penal Code 1860 and forthwith hand over the investigation to the Central Bureau of Investigation. The case pertains to the death of 6 persons, four persons who were in judicial custody. The learned advocate point out that, as could be seen from the postmortem report of at least 2 of the victims, it is clear that all of that they had severe injuries in the body, and this could not have occurred but for certain police excesses which would have taken place inside the correctional rooms. The court earlier directed a report to be filed by the concerned police, and the chief controller of Baripur Central Correction Home had filed a report dated 16th January 2023. Thereafter, there appears to have been no progress in the matter, though the learned state counsel appearing for the state would submit that inquiry was conducted by the concerned chief judicial magistrate. No, conducted by the learned chief judicial magistrate, South 24 Parganas, to examine as to whether the cause of death was due to unnatural causes. It is almost a year since the incident occurred, and till date there has been no appreciable progress in the investigation, and the wrongdoers have not been brought to books. Therefore, prima facie we are of the view that the state police, which is currently investigating into the matter, have failed to make the required progress considering the sensitivity of the matter. Therefore, we direct the
there are 4 different cases, my lord. Paragraph 5 of my report, my lord, says, my lord, the 4 different.
Therefore, we direct the first respondent, namely the principal secretary, an additional chief secretary, Home Department.
My lord, DG of the, my lord, the CID can be directed, my lord. Director General, my lord, of CID, my lord. I don't, my lord,
Director General is not a party.
my lord.
Therefore, we direct the Director General of Police, West Bengal, to immediately transfer all the 4 cases to CID. And they should take up the matter for investigation and file an action taken report on the next hearing date. Let the matter appear on 19th June.
My lord, may I make one prayer, my lord? My lord also calls for the report of the learned CJM.
Obviously, the investigating authority shall call for all the relevant reports, including the report prepared by the learned Chief Judicial Magistrate.
My lord, grateful.
Director General, this is added as the respondent, added as the 9th respondent to the writ petition. The learned advocate for the petitioner is granted leave to amend the cause title of the writ petition in course of this day.
My lord, grateful, my lord, grateful.
Serial number 13.
I am for the petitioner, my lord.
Lord, we are in default. Your lordship sir directed us to take instructions. But kindly, Lord, please keep it next week, Lord.
Next week. We have heard so and so at the request of the learned advocate for the respondent. List next week, next Tuesday. Next Tuesday, Monday, next Monday. It will come on 8th May.
Serial number 14.
This is my application, the respondent number 10.
In this matter, I have challenged a notification in annexure P8. In annexure P8, page 29. That is, I am pressing the annexure. That is on being directed, I am to convey the approval of the government to engage Dr. Gautam Bandyopadhyay in the post of principal at the Annodaya Polytechnic College for a period of 1 year with effect from 1/6/2022 or till the post is filled up by the regular full-time principal, whichever is earlier, as a special case. During the period of engagement, he will draw the same monthly remuneration he was drawing before attaining 65 years of age. Now, it is there is no provisions in the state of West Bengal to engage anybody beyond the age of 65 years, as would be evident from annexure P4, page 24, and annexure P6, page 26. First, I am placing the annexure P4. P4, page 24. In view of queries from some corners regarding the age and suitability of retired employees from other departments for re-employment in terms of this department's memo number 10935 FP dated 5/12/2011, the undersigned is directed to clarify as follows. Re-employment shall not be granted beyond the age of 65 years under any circumstances. Thus, the age of retired employee should not exceed 64 years on the scheduled date of joining.
Who appears for the state?
Well, I am not aware who is appearing.
You are for the.
I am for the private respondent, or rather respondent number 10.
10.
I have got very small things to submit before lordship permits.
And why he is such a his services are indispensable, is it?
Very unusual situation, my lord. This letter, what my friend is reading, is of 1st of June or 8th of June 22. My client is otherwise holding this post up to 31st of May 23. Today we are on 2nd of May 23. He comes up with an application now only to defame and insult my client. There is no reason
Maybe
otherwise
in the last 1 month, he is all set to win the whole institution. It will cause irreparable loss down the institution.
Why can't you fill up the post by a regular?
May I submit if your lordship permits me?
No, let them.
No, I'll tell you.
It is under their grace. Your client is.
Yes. May I say this? First of all, in 2019, AITC has issued a circular which is paragraph in 2.12 of the regulation which was notified by the Gazette of India on 1st March 2019, that the age of superannuation of all faculty members and principals, directors of institutions shall be 65 years.
Yes.
An extension of 5 years till the attainment of 70 years of age may be given to those faculty members who are physically fit, having written technical books.
That is correct. All India Council for Technical Education has given this window. But he is referring to your memorandum, which says that beyond 65,
That
you
is
don't.
my lord of 2012.
No,
That document is of 2012.
2016. 2012.
Yes, my lord.
First is 2012, next is 2014. Now, when was this regulations amended?
2019.
AICT regulation.
Yes.
65.
Who is the writ petitioner, sir? Who is the writ petitioner?
Writ petitioner is the local resident of Hon'ble Polytechnic College. He is very much associated with.
Just to say this, my lord.
He is very much associated with Hon'ble. From his very childhood, he is associated with that
Maybe
institution.
the landlord who wants the tenant to vacate it.
But the AICT regulations will prevail over all
Everybody.
notifications.
AICT, that has not yet, that is it's still in the proposal form.
No.
It has not yet been affected.
First March
As yet.
2019 was
I've got
I'm having the copy of the notification. It is 25th February 2021.
This already Gazette publication has been effected.
1st of March 2019.
This will be applicable for those sponsored polytechnics of the state from 60 with effect from 1st February 2021 who are in service on 1st February 2021. That is scheduled to retire on or after 28th February 2021. Here in this case, he has retired in 2017. This notification is certainly not applicable to this respondent. I am having the copy of the notification dated 25th February 2021.
No, they have given copy of the notification dated 1st March 2019.
Yes.
And on what date he
I am
attained?
having 2021 copy. Just see, that is
No, 2021, by
2021. That is for those only who will be retired
sir,
effect from 1st February 2021.
services were extended by an order dated 8 June 2022.
My lord, yes.
Yes.
On that date, the notification dated 1st March 2019 held the field. And in terms of the notification, this 5-year period, they may consider. That's what it says. The age of superannuation, all faculty members and principals shall be 65. Extension of 5 years till 70 can be granted.
No, but as per this notification, that is the latest notification, 2021.
What does it say?
It says that 25th February 2021. 65 years. I have marked it. Those who have retired in between the date it is given 2021. He has retired from his regular service in the year 2017. So this notification is not applicable to him. We have also gone through this notification. Normal age of superannuation of this 10 is in the year 2017.
On what date he attained the age of superannuation?
He has attained the age of superannuation in 2017, 31st May.
No, you showed an order of 2022.
Yes, 2022. First, he has joined in this this institution by virtue of an order accorded by the governor. That is in annexure P1, page 18.
No, your case is extension was granted after he retired.
After he retires.
When did he retire?
He retired in the year 2017, 31st May.
31st May.
31st May 2017.
On attaining how many years? 62?
60 years.
60 years.
60 years.
But how do you extend this benefit? See, this speaks of extension of 5 years, which means if suppose 2017 or 2019, he attains the age of 60, 5 years can be granted.
No, extension of 5 years till the attainment to 70 years of age.
May be given. That is true, but he retired in 17. You called him back and then your client was been appointed.
Yes, he was appointed. He is the person who has done so many works for this particular college, my lord, or else I wouldn't have said anything.
Now here in Mr. West Bengal, only for VCs and doctors, they can work till the attainment of age of 70 years. Only VCs of universities and
All
doctors.
right, now
I can't understand.
his term is coming to an end on 31st.
Yes, 31st of May.
You're too late.
But this last 1 month is extremely vital for the institution. He is all set to ruin the institution by all means, making the institution irreparable loss and damage.
Where is the allegation there? In the application, nothing said against my client.
Sir, his extension, if suppose the petitioner is closely associated with the institution.
Yes.
He should have known about it in July 2022.
Yes.
At the fag end of his period of extended
No,
service.
actually, we have filed the petition almost 1.5 months back.
No.
Your lordship has been pleased to dismiss since the Gautam Bandyopadhyay was not made a party by name. Your lordship has permitted to withdraw that petition and file a fresh one.
All right.
It causes delay nearly for 1 month.
When was the first writ petition filed?
First issue, I have annexed it. I have annexed the first order.
Last 11th of April.
First annexure, annexure P. First annexure. That is, I think, in page.
And this one was filed probably on 21st of April, if I'm not wrong.
No, this was in April.
Yes, my lord.
Yes.
April 2023.
Yes, my lord.
This man was engaged sometime in 2022.
First, page 20, 11, just come to the order date 11th April 2023.
Contractual, is it? No, actually. Extension. For 1 year. This extension of to 65 years age of retirement was passed in the year 2019. By then he had already retired.
Yes.
So therefore this benefit will not accrue to him.
My lord, kindly allow me to read.
See, the age of superannuation of all faculty members
Principles of
shall be 65.
An extension of 5 years to the attainment of 70 years of age may be given to those faculty members who are physically fit, have written technical books and have an average 360 degree feedback of more than 8 out of 10 indicating them active during past 3 years of service.
Actually, your case should be, this is only a contractual engagement.
Yes, it's absolutely contractual
In
engagement.
any case, is a contract, but there is no
See,
embargo on the appointment.
And your reliance on this notification will not improve your case because they have not extended his age of superannuation. First of all, he retired on attaining 60 years.
Yes.
He has gone home. Then there is a vacancy in the post of principal. For 1 year, they have engaged him on contract basis.
Yes.
So therefore, these notifications will never apply. It is pure and simple contract.
Absolute
Yes,
contract, my
but not beyond the age of 65 years.
By
This
this-
contractual
All right, we
engagement.
have heard you, sir. By this public interest litigation, the petitioner would contend that the 10th respondent cannot continue as principal of the 9th respondent institution as he has already crossed the age of 65 years. In this regard, the petitioner places reliance on certain notifications issued by the government of West Bengal, dated 4th January 2012, 19th September 2014, and 25th November 2016, stating that no teacher or principal of any institution can be engaged beyond the age of 65 years. The 65. With this, submission, the petitioner would state that the engagement of the 10th respondent by order dated 8th June 2022 is illegal and irregular.
No, the engagement was on 1st June 2022.
On going through the order dated 8th
Effective 1st of June.
Effective 1st of June.
8th June 2022 with effect from 1st June 2022. On a reading of the order dated 8th June 2022 issued by the Joint Secretary, Technical Education, Training and Skill Development Department, Government of West Bengal, the engagement of the 10th respondent was purely on a contractual basis for a period of 1 year with effect from 1/6/2022 or till the post is filled up by regular full-time principal. It is not clear as to whether the recruitment process has commenced. In any event, the services of the 10th respondent shall not be extended beyond 31/5/2023. And in case the recruitment process for a regular full-time principal is not completed by then ad hoc arrangement may be made by the department to give charge to appoint a principal in terms of the notification, in terms of the notifications issued by the All India Council for Technical Education. Thus, we make it clear that the services of the 10th respondent shall not be extended beyond 31/5/2023. With the above direction, writ petition disposed of. Next.
Not in the last 1 month, it is extremely vital for the institution. Because after this order, he will be further aggressive to ruin the institution.
All right.
Anyway, grateful to you.
209.
Affiliate site, monthly list, serial number 209.
My lord, in this matter, I am for the petitioner. My lord, this matter was heard earlier and your lordship direction for filed direct the district magistrate to inquire and submit a report. My lord, last occasion on 4th of April, my lord, the respondent filed a report and directing the served copy of the report. My lord, no copy of the report was served to me. My lord, I want to file also exception to the report. My lord, without.
But where is the report? Nobody is appearing for the state.
My lord, Mr. Tapan Mukherjee appear in this.
Mr. Tapan Kumar Mukherjee appear. Where is Mr. Tapan Kumar Mukherjee? Now, copy of the one report is here. This copy is not been given.
No, my lord. Although in spite of your lordship direction, my lord, on 4th, a copy handed over, thereafter receive, take back for xeroxing, or thereafter not hand.
You do one thing, you take a photocopy from this.
All right, my lord.
And file your exception.
It is.
Heard so and so. None appears for the respondent state. Though in our earlier order, dated 4th April 2023, we had directed the learned advocate for the state to supply a copy of the report dated
4th of April, my lord.
No, 1st of March 2020.
Yes.
Suppose don't give a date at all.
Which was.
There are 2 reports. One doesn't have a date. You show this report.
One is first of March
21. This must be the report, I think. You show him this copy, whether this is the.
My lord, earlier report I have received.
This one.
Yes,
Now this.
no, my lord, this one.
You have received.
Yes, my lord, earlier it was served me,
But
my
the-
lord, on 4th of, another report filed on 4th of April, my lord.
That copy is not here.
My lord, your lordship ordered.
All right, none appears for the state. We have heard so also. List the matter next. Let it remain in the list. Then you will take it. No, or we'll do one thing. We pass over the matter. You please inform Mr. Mukherjee. We'll pass over the matter. We'll take it after the passovers. Next.
Serial number 210.
210, my lordship was kind enough to direct state authority to file report.
Hmm.
Report of the investigating agency, it's a jail death, my lord. A lady of 36-year-old and kept in solitary confinement more than 66 days. Though, my lord, in the jail code, there is no such provision to keep in this fashion. My lord, since he is, my lord, 36-year-old, my lord.
What happened to the report?
Report, my lord.
Just giving a lot to the background. It's true that there are unfortunate death of a particular inmate of a jail. All requisite steps that are required to be done in case of custodial death have been complied with, inclusive of intimation to the National Human Rights Commission, who go into the matter. They have delved into the matter. They have said that there was certain amount of lack of vigilance because this lady committed suicide, although there were two wardens present over there, the female ward. Similar, the National Human Rights Commission has directed compensation to be paid to the next of kin. Compensation has been done. National Human Rights Commission, after receiving the compliance report, has closed the case. But my lord, your lordship wanted me to file an affidavit to bring it everything on record. My lord, it is there, my lord. If your lordship considers this, as well as, my lord, I'm giving it to him, as well as.
You can give one copy to your friend.
Your lordship had also asked. The service commission.
Let me allow to check it and to come back,
So
my lord, within a week.
thereafter, my lord, if your lordship sees the previous affidavit once.
Let me allow to, my lord, to check it and come back within a week.
I will just like to highlight one. আগেরটা কোথায় গেল?
The deceased was a life convict.
Life convict, my lord, she
Appeal
prayed,
is pending.
yes, my lord, appeal admitted, and my lord allowed her to, my lord, move for the bail application. My lord, at this juncture, one cannot commit suicide. She was kept in, my lord, solitary confinement 66 days in violation of the all jail provision of the jail code. For that, my lord, the two unfortunate wardens are not responsible. It is the superintendent of that particular jail. Even if we assume this is a case of suicide, my lord, we are suspecting foul play also. She is 36-year-old lady, my lord. That being the situation. My lord, lordship was kind enough to
National
direct them to
Human
file,
Rights
my lord.
Commission has got into the whole thing.
No.
They are the
And where is the copy of any copy of the report of the human
It's
rights?
there, my lord. If lordship takes my affidavit dated 18th of November 2022.
Here, lordship was kind enough to direct them to file the investigating agency's report, not
Yes.
domestic inquiry and nothing of this sort.
Lord,
So that is required to be complied.
18
All unnatural death are to be taken into consideration in appropriate manner.
18th
And
of
fashion.
November 2022, my lord, the affidavit, if your lordship has got that.
Hmm.
Yes, my lord. My lord will kindly come to page 13 of that. That is the where the national human rights are for. That it begins. Then, if your lordship, the entire thing, it is there, and it comes to
There
an
are two issues to it, sir. One is whether there was lack of supervision, etc., by the female warders in the jail. The next is it a case of a suicide? That the criminal angle, that investigation should have been done.
Yes, my lord. Deeply obliged, my lord.
And you may have a closure report saying that there was no, what is a
that is
inducement.
exactly, my lord, what is done by the National Human Rights Commission. That is the
Yeah, that is different, sir. What they can do, they can make a recommendation
Yes, my lord.
to the state. But should you not, do you not have an in-house mechanism in the state police? The death has occurred in the correctional home. She was a life convict. He is a 66 years.
there is a judicial inquiry by a
That
judicial
is not there in this.
No,
affidavit.
judicial magistrate inquiry did happen.
In this affidavit, we had directed in our order dated 11th April, though two reports have been filed by the appropriate authority, the report does not deal with the aspects as regards investigation done by the appropriate investigation on the death of the said person while in the correctional home. No, this report speaks of the service matter. Charge sheet was filed against 3 female warders, and then they found out that this one Anita Roy or some Roy was.
But may I say, tell you, lordship, my lord, if my lord kindly comes to
We had gone through those two reports and thereafter passed an order.
no, my lord, may I say this? My lord, a judicial inquiry was duly done because I'll tell you,
You
lordship.
please bring it on record.
My lord, that reference to that, would your lordship just gives me a minute?
Judicial inquiry in terms of the 176(1)(a), my lord. After, my lord, in each jail death and prison death, or my lord, the police death, my lord, is a mandatory provision. But at the same time, my lord, all unnatural death is required to be registered and investigation is required to be made by the law enforcing agency. My lord, the magistrate is not the investigating agency.
Page 45.
Magistrate is not the investigating agency.
Page 45 of the affidavit, which was affirmed on 13th January 2021.
Yes. Page?
Page 45.
But what do you say this judicial magistrate has conducted a full-fledged inquiry and he has recorded that during my judicial inquiry, no foul play was detected as far as resulting in the death of Srimati so and so.
Will kindly see, my lord, page 40 of the same report. The inquest report categorically stated apparently there is no foul play. My lord, marks of violence or struggle not found apparently. Lordship, kindly see page 40 of that said report. Lordship will get, my lord, from the
No
inquest.
wound or other torn piece of blanket trying to the neck knot was found on the left side of the neck. Limbs were lying straight, now finder so and so, half closed eyes were so and so.
My lord, that one at the bottom of that particular paragraph, marks of violence or struggle since, my lord, 36-year-old lady kept in solitary confinement. Our apprehension is, my lord, there may be a foul play.
But
If not found
more than this, what has to be done?
Lordship, my lord, the investigating agency is the foolish, my lord, not the
No,
magistrate.
the judicial inquiry
My
conducted.
lord, it is mandatory form. It is mandatory form in terms of the 176(1)(a. My lord, has to be done in each and every case. And at the same time, my lord, since he is kept in, my lord, 66 days in a solitary confinement, the appropriate investigating agency should come forward. My lord, at least to instill confidence in the mind of the people, there was no foul
The
play.
family has not come. The family has not come.
There is no foul play. That is why
The
this
family
public.
has not come
That
before.
is why this is public
This
interest
is-
litigation, subject
this
to
is-
correction, my
This
lord.
is somebody else.
Subject to
that I have
correction, my lord.
proposed.
Subject to correction, my lord, kindly see 66 days kept in solitary confinement in,
Sir, you have been saying the same thing.
my lord, in violation of the law.
Only today,
Lordship.
this report of the judicial inquiry conducted by the magistrate.
Yes, my lord.
So nobody has impugned this report. And you
Lordship.
want some
No,
other
my
thing?
lord, we have filed our exception. We have filed our exception. Kindly hear us, my lord, so far our exception is concerned.
Alright. In terms of the directions issued earlier, a report has been filed. Copy of the same has been handed over to the learned advocate for the appellant who seeks to go through the report and make submissions.
Lordship.
July. Next.
Serial number 211.
Deeply obliged.
The earlier matter 209, Mr. Mukherjee is not come to court today. I have talked about the report. If he is out of station, take it next Monday, my lord.
All right. Item 210. It is a
209, my lord.
209, sorry. Heard so and so learned advocate. The learned advocate appearing for the state is not available today. Let the matter appear in the daily list next Monday.
Much obliged.
211.
My lord.
This is my affidavit of service. In this matter, initially, we served the copy of the application and it was duly and properly served. Since they are not appearing, once again, we sent a letter of intimation. But in spite of that, they are not coming. So far, the disputed plot of land is concerned.
But why state also is not represented?
Yes, we have served upon all. Your Lordship, kindly have a look at the evidence. State is a party.
State is a party, but there is nobody here.
Twice we have intimated, twice. Now, if your Lordship so pleased, we can once again I can.
No. Who appeared last occasion?
The respondents.
So served somewhere in February 20.
Subsequently, we have intimated to all.
15th November 2022. All right. The learned advocate for the petitioner is directed to serve fresh notice on the learned government pleader. So far as the official respondents and also fresh notice by speed post to the private respondents 6 to 10. List the matter after affidavit of services filed.
Well,
Serial number 212.
Yes.
But may I submit your lordship? This is the compilation, my lord, my learned senior friend, my lord, supplied to me. This is
My lord, he is already just now requested me and he said already read the judgment.
Now, my lord, he has been
My
covered
lord,
by
it is my lord, Madras Maharashtra, there are a number of judgments, your lordship.
You have to revise it, sir. There is no other.
I know, I have to give me a chance.
You amend the rule or we strike it down?
I know, my lord. It will come back, my lord.
My lord, this has been, I mean, adjourned number of times at their request, my lord, and it's a very well established, my lord, principle of law. And I don't even need to argue, my lord, this
But
matter.
this CGST Act, nobody challenged it.
No, CGST and West Bengal GST Act, my lord, the appellate for advanced ruling as well as appellate authority, it constitute one technical member from the state and one from the center. There is a total absence of the judicial member, and even before the appellate authority, there is an absence of judicial member. And my lord, the difficulty is that it is not that they are, my lord, totally insulated from their regular revenue service. My lord, it is the commissioner of the tax who sits in the capacity of the appellate authority, and the commissioner of the central tax sits in the capacity of the. So where is the my lord, any expectation of any justice from such an appellate authority, or my lord, even the advanced ruling authority? And advanced ruling authority is a joint commissioner level officer.
But in any other high court, have they challenged this provision?
I do
My
not
lord,
find.
this particular whether the challenge I am not aware of. But my lord, in the Madras High Court, my lord, one second.
There hasn't been.
My lord, in the Madras High Court, the constitution of tribunal itself was challenged, your lordship, and that was struck down. Constitution of tribunal under the GST Act, that was struck down, your lordship.
But there's
Because my lord, there in fact, my lord, one judicial member was there, one technical member from state, one technical member from center. And my lord, Honorable Madras High Court struck down that constitution on the ground that, my lord, the technical members cannot exceed the judicial members. There should be a dominance of the judicial member in any tribunal, my lord. So the only question is, my lord, whether this.
No, that was a tribunal. This is an advanced ruling authority.
My lord, advanced ruling authority, my lord, there is a judgment of the Honorable Supreme Court, Columbia, my lord, kindly refer to that judgment, only one paragraph. My lord, whether authority for advanced ruling can be called a tribunal or not, that, my lord, that is the aspect, my lord, which lordship needs to look at.
But have they filed their affidavit?
Well, I have
My lord, they have
my
filed,
affidavit,
my
my
lord,
lord.
both the center
Union
and
of
state.
India have also filed an
But
affidavit.
kindly have a look at paragraph 15.
My lord,
One second.
whatever fallen from your lordship, my lord,
kindly-
have a, my lord, pan-India effect, my lord.
My
So,
lord,
I-
kindly have a look at page 10 of the compilation, paragraph 15. Only one paragraph, your lordship. Whether the authority for advanced ruling can be considered to be a tribunal or not.
Income Tax Act.
One second. As section 245S expressly makes the advanced ruling binding on the applicant in respect of the transaction, and the commissioner and the income tax authority subordinate to him, the authority is a body acting in judicial capacity. H.M. Sirvai, in his book Constitutional Law of India, 4th edition, while discussing the test for identifying judicial function in para so and so, quotes the following passage from Professor D. Smith's Judicial Review on page so and so. An authority acts in a judicial capacity when, after investigation and deliberation, it performs an act or makes a decision that is binding and collusive and imposes obligation upon or affects the right of the individual. We have therefore no doubt in our mind that the authority is a body exercising judicial power conferred on it under chapter 19B of the Act, and is a tribunal within the meaning of the expression in the Article 136 and 227 of the Constitution. So, my lord, it says that if the decision of the authority for advanced ruling binds the applicant, and my lord, also it decides the question which creates an obligation or the affects the right, my lord, then it is a tribunal. Now, my lord, in the case of the GST, my lord, kindly have a reference to section 97.
All right, today they are not ready. What to do?
It has appeared so many times, my lord. So many times they always seek adjournment on this particular matter. At least 7 to 8 adjournments. Yes.
My lord, fixed a date after, my lord, the vacation, my lord. My lord, this is a pan-India, my lord.
And
this is a learned ASG is actually.
also, you have filed your affidavit.
Lordship, the affidavits have been filed.
And what is your stand?
Lordship, my stand in regards to differentiating, Lordship, section 101A of the Central Goods and Service Tax Act. Lordship, there has been a proposition to come up with a tribunal in a seclusion which is provided under section 101, Lordship. So hence, your Lordship, there is a clear distinction. What, as per the section 101, it provides that neither the appellate authority for advanced ruling and the authority for advanced ruling can be coined as a tribunal.
As of now,
No,
Lordship,
he-
but the
My lord,
subsequent
section, there is no
elections,
reference to 101 in my application.
Goes
That
otherwise,
is relating to the tribunal.
His
It
case
has
is-
no relevance to my
He
case.
refers to this Columbia Sportswear to say that the advanced ruling authority exercises judicial power. So if it exercises judicial power, should there not be a judicial mind in the AAR? And he has referred to this R. Gandhi.
But that is the whole
Gandhi,
question.
my lord, that is one paragraph, my lord, I wish to refer to in the R. Gandhi judgment, your lord said. Kindly refer to paragraph 114 on page 75. But forget about the absence of the judicial member. When the manner in which the technical member is appointed, even that is foul to the established principle of law with respect to the constitution of a tribunal. My lord, kindly refer to paragraph 114, page 75. Let us now refer to the dilution of independence. If any member of the tribunal is permitted to retain his lien over his post with the parent cadre or the ministry or the department in which the civil service of his entire period of service as member of tribunal, he would continue to think, act, and function as a member of the civil services. A litigant may legitimately think that such a member will not be independent and impartial. We reiterate that our observations are not intended to cast any doubt about the honesty and integrity or capacity and capability of the officer of civil services, in particular those who are of the rank of joint secretary or for that matter even junior officers. We are referring to is the perception of the litigants and the public about the independence or conduct of the members of tribunal. Independence, impartiality or fairness are qualities which have to be nurtured and developed and cannot. My lord, here, my lord, the difficulty is that it is not that they are having lien over their post. They are acting as such officer while continuing to discharge a member of.
More damaging.
My lord,
that is more damaging.
That more damaging. That is what I'm saying. And my lord, I am saying with all responsibility, my lord,
If he is a former principal commissioner, then he is drawn into the AAR. this way.
But we have to demonstrate before Lordship at one point. These the orders, under the GST Acts, of the Advanced Ruling Authority or the appellate forum to the Advanced Ruling Authority, these are the quasi judicial orders or the judicial orders. If
He
it's a
refers to
judicial order,
Columbia Sports.
we have to distinguish on facts.
Yes.
That is why I will come back after the vacation. Any day fixed for the hearing, I will come back. Judicial mind lagbe na. Absolutely. Judicial order hoy tale judicial mind lagbe. Go to the court. You go to the section.
I was telling Lordship, Mr. R. Gandhi, who is the petitioner, he is my senior.
yes, your lord, sir. I know that.
So he was the president of the Bar Association then, when this litigation was started. Mr. Arvind Dattar only.
My lord, Datar Sahab has argued on this unconstitutional tribunal
And all
every
cases,
time.
all cases he has succeeded.
And my lord, one paragraph, my lord, which I wish to refer to, page 146, my lord. This is a very recent judgment. Page 146.
See, the basis is first is Sampath
Basis
Kumar,
is, yes, your lord.
then Chandra Kumar.
Yes, your lord.
Chandra Kumar is my colleague,
Yes, your lord.
same office. So first is Sampath Kumar, then Chandra Kumar, then all these matters came.
Yes, your lord. This is a very recent judgment.
Page
146.
Chandra Kumar is for the superintendence. Superintendence of the High Court.
Yes, dispensation.
Dispensation of justice by the tribunals can be effective only when they function independent of any executive control. This renders them credible and generates public confidence. We have noticed a disturbing trend of the government not implementing the direction issued by this court. To ensure that the tribunal should not function as another department under the control of the executive, repeated directions have been issued which have gone unheeded, forcing the petitioner to approach this court time and again. But this is a problem here also. My lord, they were very much conscious even while constituting the tribunal. Time and again, my lord, the Honorable Supreme Court has issued direction that, my lord, the tribunal should be dominated by the judicial member and only if required, only then the technical member should be there. Otherwise, my lord, it should be wholly comprising of the judicial member. If required, then technical member can be there, but technical
No, technical member is required.
required, my lord. I'm not saying that in this
But
case
the
it is not.
supremacy should be of that of the judicial member.
Yes, your lord.
If it is, these two people can gang up together and veto the judicial member.
Yes, your lordship. And in my case, your lordship, in the this advance.
You take, for example, income tax appellate tribunal.
Yes, your lordship.
Or SEGAT or SESTAT. They have all got a technical member and a judicial member.
Yes, your lordship.
If there is a difference of opinion, third member takes a decision.
Yes, your lordship.
But only decision, the distinction, they say it's a quasi judicial.
That has come on a
problem.
I have to demonstrate that, my lord.
If an assessee goes before the AAR and there is a ruling given,
Yes.
it binds the assessee concerned.
It binds the SSC. Yes.
It binds the department otherwise.
It binds both. It binds not the department, but the concerned officer who is a party. Suppose I am having 100 registration all over the country. Then it binds me and it binds the officer who under whose jurisdiction I am applying. Because suppose
No. It will bind the department in the sense if he culls out the legal position and says, let us say, under which classification this product has to be, what will be the rate of tax? They do it product specific. Then the department is bound to follow the AAR.
my lord, not the whole of the department. That is the problem in the GST Act. It binds only the concerned officer who is my jurisdictional officer.
But this will not bind any other assessee.
It will not bind any other
So
SSC.
therefore, can you say that the ruling given is a judicial exercise?
My lord, that is what the Columbia Sportswear
But
says.
Columbia Exports, it is under the Income Tax Act. Are the language parameteria?
Yes, your lordship. 103, section 103 binds me. And my lord, one of the criteria for determining whether the authority for advance ruling is acting in a judicial capacity is number one criteria is whether it binds me. So if it binds me, then the presumption is that the concerned authority, it is not even talking of the, my lord, any authority. It says that any authority whose decision binds me can be said to be a tribunal. And secondly, if it affects my rights, and my lord, kindly refer to section 9 to.
I am on a submit this is quasi judicial. I have to demonstrate that, my lord. These authorities of advanced ruling, your lordship knows, decides on the facts of the each case, my lord, and my lord, the applying the law, my lord. Like my lord,
But they
the other
don't decide on the fact, my lord. They only decide
Absolutely, my
on
lord.
the
This is
question of.
personal.
Kindly refer to section 97.
Person of my lord, they have to
Kindly
decide the
refer to
facts. my lord.
section 97. They do not decide any
All
fact.
right, when
Yes,
you
Lord,
will
I'm
be
good.
ready?
But any day after the vacation, my lord, your lordship can fix the matter, my lord.
You don't know what date we will fix. We can give a date in July. June will be difficult.
This matter will remain pending, my lord.
What to do? Interesting question.
But they are seeking adjournment. My lord. Kindly keep in the month of June
But
any day.
the Madras High Court decision in that Revenue Bar Association,
Yes.
I think there's slightly a difference in facts.
My lord, the question is, my lord, the first question is whether the authority for advanced ruling is a tribunal or not. My lord, if I am unable to satisfy your lordship that it is not a tribunal, my lord, then I don't have any case.
The pleadings are complete and at the request of the learned advocate appearing for the state of West Bengal, list the matter on 3rd July, 4th July.
I'm grateful, lordship.
And in that case, they my lord, kindly note that they have sought number of adjournments. So next time they should not be seeking adjournment.
I'll not. I'm grateful, lordship.
I'm grateful, my lord.
Yes, sir.
We congratulate you, my lord.
Oh, thank
And my
you.
lord, at the cost of contempt, I'm saying we envy your brain.
And I am really grateful for other reasons. Myself and Mr. Torun Chatterjee, as he was sitting, he was a lawyer, he was a very good friend of mine. We made an attempt. During summer, we should not use this gown, only jackets. And especially in Delhi High Court, why not knows their summer.
Lord,
But
you have-
centrally air conditioned High Court, still.
No, still
And my
not.
lord issued the
It was
circular,
unbearable.
I've seen
My
it,
lord,
kindly have a look.
Sir,
I
Sir,
admit
Sir,
my gown.
you have raised, my lord, the standard, my lord. And we envy you.
Thank
We
you.
are also
Okay, let us see.
really, very first day, I had a privilege to appear before your lordship after the first case, okay? Now, at that time, my lord case was also there, probably from the bar senior. They told us, another told me, sir, Is our loss, your gain. I'm not praising, this is fact.
Thank you. Appeal dismissed, substantial questions of law are answered against the revenue. Call.
Appellate side daily list, serial number 8, password matter.
Yes.
Which we have the orders. In the
Lordship, can you see the CRM 198 of 2023, order passed on 8th of February. Lordship, page number 2, the bottom paragraph. There is a direction from the Honorable Division Bench.
We just will go through the order.
I'm sorry, man.
এটাই দেখাই ইয়েটা ৩৫ বছর ৩৫ বছর ৬ মাসের মধ্যে এইটাই
একটা দিচ্ছে সঞ্জয় দা, আরেকটা কপি অর্ডার।
আমি অর্ডারটা করে দেন এই যে অর্ডারটা দিল এটা ফেব্রুয়ারিতে না
এইটাই তো
হ্যাঁ না এইটা একটা অর্ডার দিল রুথিন দণ্ডপথে এই যে প্রিন্সিপাল এখানে কোনো ডিরেকশন নেই ছিল ওটা
রিজেক্ট করেছে
এর বাড়ি থেকেই তো হয়েছিল
So the division bench is monitoring the matter.
My lord, may I submit if my lord permits? In fact, my lord, this instant matter before my lord, not my lord, the one, my lord, which has been handed over. It was being monitored by this court number 1, my lord, that will appear from the order sheet itself. My lord, as it appears, my lord, the CRM which was filed for bail, but here it has been stated there is no subject to correction.
No,
my
no,
lord.
what we can do is, it will be appropriate for the division bench dealing with the criminal matters to deal with this. We will club this writ petition along with CRM DB 949, and we will request the division bench, because once this PIL goes before the division bench, it will be easier for them to monitor, because periodic reports have been called for, and
But that is in respect of Rothin Dandopat only, subject to correction.
Have you read these orders? Without even reading the orders of you? This is not application. We don't require your consent to club this matter with that. As a matter of courtesy, the bench is expressing what's passing in our mind. So therefore, see, there has been a progress. From 32 witnesses, it has become 35 witnesses. Report has been directed to be submitted to the Registrar General once in 3 months.
Once in 3
Once
months.
in
There
3
is a
months.
specific direction.
And specific date has been given.
Yes, and as per direction of this honorable court, day-to-day trial has been going on.
And dates for recording prosecution witnesses have been fixed in April and May 2023.
It has been going on day-to-day basis.
This public interest writ petition has been filed by the Bar Association, High Court at Calcutta, with regard to a gruesome incident which took place in which 9 people were shot dead. The division bench has been, the Honorable Division Bench has been had passed several orders with a view to monitor the investigation and ultimately the trial. The accused two of the accused had moved for bail in CRMP 198 of 2023, and the Honorable Division Bench partly allowed the application in respect of one of the accused and rejected the prayer for bail in respect of the other accused. In the said order, direction has been given. No, in the full stop. The division bench, with a view to monitor the trial, has issued various directions, including a direction to the trial court to submit report with regard to the progress in the trial before the Registrar General of this court every 3 months, so that its progress may be monitored and the proceedings be taken to its logical conclusion at the earliest. Subsequently, the accused whose bail application was rejected by order date. Oh, sorry. Subsequently, another application for bail was filed in CRMP DB 949 of 2023.
Every 3 months, Registrar General.
And in the said order, the Honorable Division Bench noted the trial is progressing on a day-to-day basis, and as per the report filed by the trial court, number of dates have been fixed in the month of April and May 2023 for recording prosecution evidence. Therefore, the Honorable Division Bench has directed, has adjourned the matter till 19th May 2023, with a fond hope that the prosecution of the case shall substantially progress in the meantime. Thus, since the Honorable Division Bench is already seized of the matter and directions have been issued to monitor the progress of the trial, we are of the view that this writ petition should be tagged along with CRMP 949 of 2023, and be listed along with the said matter on 19th May 2023.
Let this matter be placed before the Honorable the Acting Chief Justice for necessary assignment.
Yes.
Only one thing I was submitting, my lord, subject to my lord's correction. My lord, CRM, my lord, 198, my lord, has been disposed of. The direction which was given, my lord, that to complete the trial within a period of two months.
There are two matters.
Yes.
Second matter is still.
Can you allow me one? In CRM 198, my lord, the direction was there that and the report was supposed to be submitted to the Registrar General every 3 months. But the CRM 949, but is a different matter. So it has disposed of whether, my lord, the report submitted in connection with 198 will be tagged with 949. That, my lord, will kindly make.
Simply. This writ will go along with that. The division bench will monitor. Please call. Next.
Appellate side monthly.
And my lord, the one more thing, my lord, the protection of witnesses, the persons who have now by now have
That
got
is
the
why,
bail.
sir, you make a prayer there, sir. Definitely the court will grant. Yes, next.
Appellate side monthly list. Serial number 213.
I am putting my status. State. Non-item. Lord.
Yes.
Madhusundar Banerjee Road, in short, my lord, MB Road.
This matter, my lord, in terms of the direction of your lordship, my lord, there are 2 reports have been filed by the district magistrate, my lord, not 20, my lord, Pargonas. And my lord, they only have paid for filing the exception to the report.
I have ready. I have already served you.
No.
Yes, there is a record.
No, we have not served. You have been served on the other.
You have been served.
No.
Yes, this, therefore, car
I am responsible 2 and 3.
2 and 3 have been served.
Help.
Yes, help have received. Received. This is the.
My lord, my junior, my lord, has not been. My lord, you will also kindly attend this day, my lord. You will also, I shall.
Kindly.
You have filed an exception to the report.
Yes.
Where is that exception?
The purchase has been removed, my lord.
Petitioner has filed an exception to the report submitted by the respondent. You give one more copy if you have got.
I will serve them. In the
Copy of such report be furnished to the learned advocate for the respondent. At the request of the learned advocate for the respondent, June. Next.
At least of June. My lord, the matter has been referred by the Honorable Apex Court, my lord. I have been pursuing this matter since 2013, my lord. My lord, there is encroachment on the state highway, my lord.
Encroachment has been removed, my lord. There are 2 times,
No,
my lord, has been removed. And the report has been submitted, your lordship.
So every time you will remove, they will come back once again.
My lord,
Then we have to issue direction. What is it?
no, my lord,
If you have removed, you should be enabled them. I mean, you should have monitoring so that the people don't once again come and.
And my lord, in the present status, I will submit.
My lord, the matter is returnable on
5th June, monthly list of June.
Next.
Serial number 214.
Peculiar matter, my lord. More than 7 crores are due, my lord. And division bench of this honorable court, my lord, directed to treat this writ petition as a public interest litigation. Prior 28, my lord, paragraph 28. Kindly see, my lord. Paragraph 28 of the order, my lord, division bench of this honorable court. Paragraph 28. Provident fund rules. They are not even depositing the employees' contribution. Several retired employees coming before this honorable court for asking provident fund dues. Neither the board of trustees nor the company, my lord, paying the provident fund dues.
Now this appeal has been dismissed.
Appeal was dismissed.
Very good.
And thereafter, my lord, this writ petition was treated as public interest litigation.
But what about the subject matter in this writ petition?
Writ petition was subject non-payment of the employees' contribution along with dues, my lord. Kindly see paragraph 6. stated here in paragraph 6.
No,
my
no,
lord.
what is the prayer in this writ petition, sir?
Prayer, my lord, when the direction was given to pay 50% of the dues, my lord, more than 7 crore, then he want to withdraw this application. Writ petition. When they want to withdraw this writ petitioner want to withdraw. That was not allowed. And seeking against that order, prefer appeal before the division bench. And that writ petition division bench dismissed, my lord. That is, my lord, appeal, my lord, that is stating, my lord, last paragraph.
Yes,
Page 33, present
Oh, now-
appeal accordingly dismissed with cost 1 lakh rupees.
yes.
And this writ petition treated as public interest. I am simply direction, my lord, given the particulars of the state. Delta House is lying there, more than crores of rupees each and every month is the drawing. Delta House is there, my lord. My lord knows very well.
You attach,
Justice Bhattacharya.
you attach that property.
No, my lord, list of property I am not with me. No, my lord, there is no.
We are not running your office.
My lord,
You do run your office.
direct them to produce them, my lord, as per direction of single bench, my lord.
Whether
This-
there is any interim order in this.
Thereafter, my lord, kindly see this order. Done.
From order is giving.
Single bench director, my lord, this is the direction. Thereafter, also directed to file affidavit stating the properties lying with them.
They have not filed.
They are not filed.
Now, what is the prayer in this writ petition?
In the writ petition, my lord, he want to more than 7 crores are dues. My lord, that statement is there, my lord, paragraph 6. Paragraph 6 of the order of the division bench, my lord, more than 7 crores 62 lakhs.
We will dismiss the writ petition. You proceed against him.
My lord, writ petition without only dismissal of the writ petition will not serve purpose, my lord.
Then we are not your recovery
My lord,
agent.
direct them to disclose the properties, list of properties by way of affidavit, so that I shall attach and sell the same. They are not disclosing the properties and attach the rent, my lord, we are getting from the Delta House and others. That should be deposited with the Provident Fund Commissioner. Delta House.
Suppose they don't deposit. What will you do? Under the act, what is the procedure?
We have initiating even
Therefore,
FIR. My lord, even 406 we have initiated. My lord, then kindly also direct the police authority, my lord, appeared before this court. In this order, my lord, kindly see order paragraph 26, my lord. They are not cooperating. Police authority not acting on the basis of FIR. 406 we have initiated, but police authority not acting. The director of the company will appear in person.
Where is the prayer in the writ petition?
Prayer of the writ petition, my lord, that was
Cancel the decision dated 14th September 2018. Where is that 14th September 2018?
kindly see the prayer of the writ petition, my lord. Lord, writ petition.
14th September 2018 is a recovery certificate issued. Page number 45. Page 45 is the impugned order.
45 and 46.
Ah, yes. Now there is no stay of this certificate. Is there any stay of this certificate?
No.
Then why are you not proceeding further?
We are proceeding, my lord. We have several proceedings initiated by the recovery officer.
Order of attachment is already there. You bring the
That is
property.
there, my lord, but nothing remains, my lord. In the bank account, no, zero. And my lord, 406, I have initiated. I have submitted report, my lord.
You have attached the land, building and other immovable
My
properties
lord,
of
they direct them to produce the by way of evidence details of the property. Direct, simply, my lord. Direct the Delta House, my lord, read petitioner, my lord, to by way of evidence details of the property.
Yes.
And other.
Your Lordship, Shomu Majumdar is leading me in this matter. Your
All right,
Lordship.
see, this matter has been directed to be treated as a public interest
Your
litigation.
Lordship.
There was an interim direction issued by the single bench that he says you have not complied with till date. The appeal filed by you in MAT 257 dismissed with 1 lakh rupee cost not deposited. Now the details of property has not been furnished. Then what to do? We will prosecute the directors.
Your
What
Lordship,
is-
kindly take it up on the next week, Monday, Your Lordship. I'll satisfy you what steps we have taken, Your Lordship. Monday, Your Lordship, may we please.
No,
take
we
it.
will hear. Have you deposited that cost?
Your Lordship, there has been a change in brief. The earlier advocate,
That is not
Sharma
our
Kataria was
concern.
taking
No,
up this matter.
That's not our concern.
Your Lordship, kindly take it up on Monday. I'll satisfy Your Lordship
We've
on
been
the
running the
steps
list for such a long period. Then why?
Your Lordship, we didn't think 214 will be taken
No,
up
no,
today.
no. See, the cost list is very clear. So what is the determination for today, which is group 9 or PIL or whatever it is? This is a PIL. In fact, we need not even hear you in the matter.
Let them deposit, my lord. Running condition, Delta House is there, my lord. Let the entire rent should be deposited to the Provident Fund Commissioner. We will get the money within 7 months. 7 crores within 7
Lordship,
months.
kindly grant me 2 days
Yes,
time,
yes, yes.
Thursday.
We'll
at
grant
least.
you-
No, my lord, no.
No.
7 crore within 7 months, my lord.
The Honorable
More
Division
than
Bench,
crores of rupees getting, my lord.
in a connected
Delta House is there, my lord.
filed by the appellant in MAT number 257 of 2021, directed this writ petition to be treated as a public interest litigation. In this writ petition, the petitioner has challenged the order, the recovery certificate issued by the EPF organization and the order of attachment of the properties of the appellant. The learned advocate appearing for the respondent organization would submit that there are no funds in the bank account of the petitioner and the petitioner has not complied with the directions issued by the learned single bench in this writ petition when the matter was pending before the single bench. Furthermore, it is submitted that the cost of rupees 1 lakh, which was directed to be deposited by the appellant petitioner in MAT number 257 of 2021, dated 2/3/2021, has not been deposited before the West Bengal State Legal Services Authority till date. The learned advocate for the petitioner prays for adjournment. Considering the fact that more than 7 crores is stated to be due, we direct the appellant to furnish the list of all immovable properties owned by the appellant, giving full details of the property, and also truly disclose as to whether there are any encumbrances on the said property by way of mortgage or attachment, etc.
And
the names of all the directors of the appellant, along with their residential address.
To direct them to appear in person.
Residential address be furnished to the furnished before this court. Let an affidavit be filed in the setting out all these details on the next hearing date. List the matter on 15th May.
15th May. Obliged to lodge. Obliged to lodge. Poor money, my lord, and there are several retired person coming before this honorable court.
और कुछ ऑर्डर भी लीजिएगा क्या इसके बाद भी?
In order to ascertain as to the source of income of the appellant, not appellant, sir, petitioner. The petitioner is directed to file the audited balance sheet and profit and loss account of the writ petitioner for the 3 preceding years.
So many retired person
Your
coming.
Lordship, our mill has not been running for the last 2 years. We have just started
But
the
then,
mill.
Namrata,
Your
this
Lordship,
is-
so the balance sheet will show how losses we are suffering. Your Lordship,
But,
that
you-
helps us to show before your
No,
Lordship.
but your directors are all comfortable.
Your Lordship, they are not at all comfortable. They are all in a, one of them just had a heart bypass, Your Lordship. They are in a very bad
But then,
condition.
this is statutory due.
Your
Your
Lordship, it
recover-
has to be paid. That is the reason, Your Lordship, we had filed this
Oh,
application so
therefore,
that installments could be granted. We renew our prayer
On
that
that time
installments could be
you-
granted.
you-
We want to pay.
You did disclose the list of properties.
Your Lordship,
We will see whether the encumbrance is there or not. Then we will arrive at a figure. Of course, they would have added interest, etc. Now these fellows, if they get even, if they are supposed to get 100 rupees, even if they get 60 rupees, they'll be happy. So we do some discounting, make a round figure, put up the property for sale by probably a court-appointed receiver or commissioner. Then let them appropriate the dues, be done with it. Otherwise, a never ending, every court, writ court, your client is here. Even in this short span of 1.5 years, I have seen so much of your delta. It shows that these people are so powerful.
Your Lordship, this is the condition of the industry in West Bengal, Your Lordship. This is not one company. In all the companies, they are not in a running condition. Most of the jute mills, because of the prices, the jute prices had gone high. They would operate for
But
1 year.
in Bangladesh, it is flourishing.
Your Lordship, but over here, the jute minimum price has been increased, Your Lordship. So they did not function. Any of the jute mills didn't function for one continuous year, Your Lordship.
Employee share should be deposited at least. Employee share, that is not his money.
Your Lordship, we want to
And those
deposit.
who
We are just
retired,
asking for installments to
Before
do
this
that. Your Lordship.
provident fund dues, asking provident, they are not.
I have an application for on behalf of the unions. And in respect of not the conduct not displayed by or exhibited by Mr. Gupta's client to accommodate certain employers. Only not issuing show cause notice.
After some time, even the regional provident fund commissioner will start identifying the employees. Because every day morning, if suppose 100 people are standing in his office.
Not employees, not in some cases with the employers.
Employers. That is why it has become 7.5 crores. You have given a long rope. All right, check will bounce. You won't attach the account.
Not only that, not a defaulting employer is accommodated by way of granting installments.
Since
72
2017,
installments.
if he willing to
2011, an exemption is cancelled.
Paid. Delta
Exemption
house
is cancelled. An application is
more than
made
50 lakhs.
so as to gain
Course of
advantage as an exempted establishment. The recommendation is towards grant of installment in 72.
And they are coming before employees.
In the meantime, what happened? That trust, that amount lying in the credit of the
Those who
trust
retired.
was siphoned off to some other companies.
And that is not his money. Employees contribution, that is not his money.
See,
correct, sir. The money is not here.
Why deducted or not deposited?
No.
That 406 we have initiated. Police is also not cooperating.
They
are helping him. Police are also not cooperating. They are helping them not to arrest. FIR, several FIR lodged.
No, we will direct them to be arrested.
And notice to show cause did not appear. Notice to show cause, warrant issued. No, don't bother.
No.
Don't even care for the Hon'ble court's order, my lord.
Please hear us. In one matter, all the directors came to courtroom number 16. Ask her.
Yes, my lord, it is only my lord's endeavor. Otherwise, nobody dared to touch him.
No.
My lord, even police are afraid of them. I do not understand why.
We are so powerful, everybody is afraid, but Mr. Anil Gupta is not afraid of us. That's the irony of it.
All you say is 100%.
Implies come before my lord asking for provident fund dues, my lord, after retirement.
Serial number 215.
What date we have given? 15th May.
Serial number 215.
File in department. But where petitioner is not at all appearing. You go, where they will trace, sir, you go to the department. The matter in the cost list, it is stated that the file relating to this writ petition, namely WPA 5378 of 2020 is in the department. However, it appears that the department states that the file is not with them. The registrar, who have the superintendent? No. Little
Superintendent.
the superintendent, Mandamus appeal section, Mandamus section is directed to trace out the file and place the same before this court on the next hearing date, June. Next.
Let this order be communicated by the concerned SEO to the superintendent concerned by culprit date.
Next.
Serial number 216.
We appear for the writ petitioners. The state respondent has used an affidavit, report in the form of an affidavit, and we have taken out an exception to this also. The fact is that there is a forest region in the district of Purulia where illegal felling of trees were alleged by the petitioners. Being the members of a forest protection committee, there are two villages. Two villages have conjoined to form a committee which is sanctioned by the act itself. They would help the police authorities and the forest officers to ascertain whether some illegalities formulates or not. But we have alleged the illegalities, felling off of trees, and they have admitted in their report stating that there has been illegal felling off of tree for around of 5 hectares of land. Although in their report contradictorily, they have said that the petitioners were also involved in such felling off of trees. They had stated that in the report. We have taken that exception, taken out the exception stating that all such allegations and FIR has also been lodged. They have stated.
What is the species? Very rare species? Or?
These are tall trees, named as shal trees in our vernacular.
It is used for furniture. And
Yes. And entire area is being
see, illegal unauthorized cutting of trees. That is one prayer.
Yes, Malad.
To take action against the private respondents, 10 to 14.
We had made these.
And they say you are also involved in this.
Yes, they say. They kindly takes their report, which have been there, at page 3, paragraph 5. They state that there has been illegal felling. Although they substantiate the part of the private respondents being the persons authorized to do it.
1 second. Petitions.
Well, all such incident happened during the first phase of lockdown.
But the petitioners have been named in the FIR.
Yes, but the interesting part is the FIR that has been lodged. I have gone through the FIR, my lord. I will take your lordships to that also. My lord, that FIR, my lord, particularly speaks about illegal fencing of the land which were trying to be protected by the petitioners.
No
it does not deals with the the purported illegal felling and taking away the trees by the petitioners. My lord, the FIR has been annexed.
No, ultimately in the report, what do they say?
They say, my lord, kindly takes up page 3, paragraph 5. My lord, the line starts during the lockdown period in between.
Yes.
During the lockdown period, about 4.49 hectare of Shal forest area at Chok Muktapur Moza was illegally cut down by some miscreants suspected from the Lauria village.
What we can do is.
Yes, ma'am.
So far as the trees which have been unauthorizedly cut, there is a policy of the
Yes.
government.
Yes.
Replanting has to be done.
Yes.
We will direct the forest department to do the replanting.
Grateful.
Secondly, we can ask them to have a more vigilant watch over the area by constituting some teams, etc. But if FIR has already been registered, that needs to proceed to the.
Yes, we say that, but the interesting part is, my lord, this FIR, which is being demonstrated by the state authorities, is the FIR pertaining to some different facts altogether. That it does not relates to what is the
So
complaint.
we will not say anything about it, but whatever action they have initiated, let them take it to the logical end.
My lord, my contention is, my lord, my prayer is they have not taken the appropriate action which they ought to have taken.
True, we can't put the tree back. No, it's already gone.
No.
They have said he has sold it for 15,000 to somebody,
Yes,
etc. Let them proceed. Further felling or illegal felling should be prevented.
And my
In
lord,
your exception, have you suggested any method? This committee you're speaking
yes,
about,
yes.
what is that committee?
It is a committee comprising of the villagers of two villages. That is one Muktapur and one Lauria.
And what is the, is there any statutory backing for such committee?
Yes, my lord. The act provides so, although I have handicapped with the act
Doesn't
here and now.
matter. What is it committee called?
My lord, it's called the village, my lord. My lord.
In your writ petition, you should
Yes, yes. My lord, it's committee called Muktapur or Lauria Village Bono Rokha Committee.
Which
My lord, page 8, paragraph 3 of my writ petition.
Muktapur Lauria Village Bono Raksha Committee.
My lord, this is the yes, my lord.
Protection. But they won't make the petitioners as members of the committee because they'll say FIR is there.
Well, the petitioners were members. I do not know. I do not have the instruction whether the petitioner is still the
We'll
members.
dispose of the writ petition. We'll direct them to follow the norms prescribed by the government for replanting. Number 2, strict vigil to be maintained to prevent like regular patrolling, etc. Third is to constitute the Raksha committee.
But there is a committee. I do not know the names of the members of
But
those committees.
if the term of the committee is over, they can reconstitute.
And my lord, lastly, what I was requesting your lordships that, my lord, the complaints that have been lodged by the petitioner against the private respondent, that needs to be looked into, my lord, and
this public interest
come to a
petition,
logical conclusion.
The petitioners, who are all residents of Lauria village,
Muktapur
village, have sought for appropriate direction against the respondent, direction on the official respondents to take action against the private respondents 10 to 14 on the allegation that they were involved in illegal cutting down of trees and having smuggled them out of the forest area. Pursuant to the directions issued by this court earlier, a report had been filed by the authority of the concerned by the Divisional Forest Officer, Panchat Division, Bishnupur, Bankura District. Bishnupur, Bankura. If on a perusal of the said report, it is seen that illegal felling of trees has occurred and it is admitted by the Forest Department. The action taken against such illegal felling of trees has also been mentioned. And curiously, the report states that FIR has been registered against some of the writ petitioners also. The report does not contain, does not state anything about the remedial measures which are required to be taken. But it is alleged that in the general meeting of the Luria Muktapur Joint Forest Management Committee, which was held on 6th August 2020 at Chagula, Chagula, Beat Compound, it was decided to debar the members of the Muktapur from the Luria Muktapur Joint Forest Management Committee as they were fully involved in illicit felling of trees. The petitioners have filed an exception to the report, stating that the alleged the allegation is absolutely false, and the FIR which is stated to have been registered is on a different set of facts. Be that as it may, the forest department having admitted to the illegal felling of trees, it has to be seen as to what steps need to be taken in the page number. What is to be done in the matter? There is a policy evolved by the state government that whenever a tree is to be cut, as many as 10 trees have to be planted so that to maintain the green cover. We find from the communication sent by the district forest officer, Panchat Division, Vishnupur, to the range officer ONDA range, dated 22nd July 2020, the following action was decided to be taken. This is the short report in that page number 40. It is not clear as to whether the above directions have been complied with or any further directions have been issued by the higher officials of the forest department. We are confident that the forest department will take more effective steps and maintain vigilance in the area so that illegal felling of trees is prevented. If according to the department, the petitioners and others are also involved in the illegal felling of trees, it is always open to the department to take necessary steps in accordance with law. The petitioners have lodged a complaint against the private respondents 10 to 14, alleging that they are involved in the illegal felling of trees. This aspect also has to be examined by the concerned authority. Accordingly, we dispose of this writ petition by directing the divisional forest officer
Respond number 4.
The fourth respondent to take all remedial steps to maintain vigil in the area and prevent any further illegal felling of trees, and whatever action they have already initiated against the miscreants shall be taken to the logical end. You have not implemented the first respondent, namely the Principal Secretary, Department of Forest, State of West Bengal, is also directed to issue necessary guidelines which can be implemented by all the divisional forest officers in the state. Full stop. The committee, so and so committee, no? The committee shall be reconstituted with persons of impeccable character and good knowledge of forest and forest produce, and they shall work in coordination with the forest, with the officials of the forest department, and take all steps to prevent any illegal felling of trees. With the above directions, the writ petition stands disposed of.
My lord have directed the committee to be reconstituted. My lord, if it is reconstituted, my lord, will it be, my lord, just to
Petitioners, unless they extricate them from the criminal offense. You are saying that's why we recorded your submission.
Yes.
That doesn't relate to this incident. It's a different.
Yes. My lord, if the committee is, I suppose that there is a committee.
But you are familiar with the forest?
Not exactly, but
because without their assistance,
yes,
the forest department cannot act.
Impossible. That is the reason the committee is constituted.
I was party to a division bench. We dealt with a so moto public interest litigation, where around 35 forest dwellers were shot dead by the Andhra Pradesh forces. So we say various things happen. They are all forest dwellers. The forest department, sit down. Forest department takes their help to protect the forest, but they are the miscreants also. And this particular tribe has got a very unique skill. They are called silent cutters. It's a huge skill. One advocate commissioner by name Dr. Suresh, V. Suresh was appointed. He went there. And even 120 feet long, a single person will carry it in his shoulder downhill. And they will use a normal axe. There will be absolutely no sound.
That is the magnitude of it.
And there are 4 or 6 tribal villages. Their only avocation is this illegal felling. There we have got these red sanders. That's very famous. Part of the mountain is in state of Tamil Nadu, part is in Andhra. I think these fellows went there, 30 people shot dead. So that is, so without their assistance,
Yes,
they can't.
Definitely. No, my lord, I was just asking, my lord, subject to what has fallen from your lordships. My lord, your lordship has said, my lord, that to constitute a village committee, reconstituted. But if it is there to reconstitute further, that is the whole thing, my lord.
It is not there because by resolution, they have removed all your claims. Next.
Grateful, my lord.
Serial number 217.
By order dated 13 February, my lord, I was directed.
13 February, he was. আমার তো এক্সেপশন নেওয়ার কথা প্রাইভেট রেসপন্ডেন্ট কি আছে প্রাইভেট
মানে অ্যাডেড রেসপন্ডেন্ট
অ্যাডিশনাল পার্টি তো হয়
না উপরে তো বলবো
এটাই আলাদা
এই তো তার অর্ডারে পড়েছে প্রপোজ প্রাইভেট রেসপন্ডেন্ট
প্রপোজ প্রাইভেট
Kilometers. Yes.
Here I am for the petition. I'm at one thing, and with greatest humility, I submit. My lord, by order dated 4th April 2023, my lord, sir, please to direct the state to file a report within 10 days and to serve a copy upon me, my lord, so that I can take within
Directed
7 days.
to file a report in the form of affidavit.
Exception. Yes, my lord.
So and so. Till now, how number of notice, how Notices issue intend enclosures. Same.
May I
effect.
place the affidavit?
Yes.
Hmm.
My lord, they have, my lord, served upon us on 24th of April.
Lordship, they have not been served upon me at least. Private,
Who are you?
proposed private respondent, Lordship.
Proposed private respondent.
And my lord,
You won't get a
because of
copy
the
though.
difficulty, my lord, in the family of my learned advocate on record, my lord, it
Lordship.
could not be done. Today is the 8th day, in fact. But your lordship will kindly grant.
Lord will kindly
Lordship,
see.
kindly see the last order, Lordship. Kindly see, your Lordship directed the Learned Council representing the state shall affirm and file a report within 10 days from date, and copy should be served on the learned advocate appearing for the petitioner and the proposed private respondents, Lordship.
Which order you are reading?
Lordship, 4th April, Lordship. They have not been served any report to me, Lordship. We are also affected party, Lordship.
You are the encroacher.
Yes, sir, Lordship.
Yes.
But not
Alleged encroacher.
alleged, Lordship.
They are encroaching.
No, this report is of no, he is only enclosing the notices
Absolutely not.
given to your clients. That's all. Nothing much.
Lord, today, my
I
lord,
have to
That
file
will
the
give you a
exception,
copy.
Lordship, if
My lord,
there is anything.
may I point out?
Sir, you have issued notices. 388 under 10-1,
Absolutely.
10-2, 218,
My lord,
10-3, 42.
my lord.
On what date the notices were issued?
Lord, I can come up with every my lord, notice. If I can file a supplementary report, my lord, but my lord, may I submit, my lord? May I submit, my lord, this?
Sir,
to-
we are not concerned about how you go about it.
I have followed, my
But
lord.
you should ensure that the encroachment is
Absolutely.
removed in accordance with the provisions of the Highways Act.
Absolutely. My lord. Lord, today, my lord, with all humbleness, my lord, I'll say this, my lord, we are deviating from the main cause of the writ petition. The cause of the writ petition, my lord, will find. My lord will kindly take up the writ petition. It was alleged there is a water logging problem in this particular area. Lord, during the inspection, we have found these numbers of encroaches there in Lord. Lord, today we have identified the encroaches. Lord, we have issued notices, and the notices will be taken to their logical conclusion. Lord, that is not in dispute, my lord. My lord will kindly not keep any doubts on that. Lord, but the water logging problem, the cause for which the present public interest litigation was filed, is, my lord, not taken up or not placed. With all humbleness, my lord, I say this, is not placed before the court. My lord, I will bother the honorable court with few of the photographs. Lakhan. And I will find both the sides of the road. There is absolutely no, there's no way of the water getting drained. There's no proper sewage line on either of the sides of the road. Well, that is the reason, my lord will find kindly come to page 19 of my affidavit. It is a letter from the district magistrate to the irrigation department, page 19, my lord. We are
Required master plan.
my lord,
Master
absolutely.
plan will take 10 years.
No, my lord, if your lordships, if it is under the vigil of my lord's court, my lord's vigilant eyes, my lord, it will not take so time, my lord.
So one is encroachment, one is water logging.
Encroachment is no, we are not much bothered because it can be easily taken care of. Encroachment is not.
Water logging is the main problem.
Yes, no, my lord. Thing is, the same mantra of my lord master plan is being chanted since 1992, 2020. My lord will find, my lord, that one after another, I can series of letters, my lord, they have issued, I can show. Only, my lord, the whatever works have been done in paper. The water logging, my lord, caused due to, my lord, encroachment, my lord, by filling up a stretch of 2 kilometers away, a khal, my lord, 4 kilometers away, my lord, a khal which was there. That I have stated in paragraph 7 of the writ petition. And my learned friend was initially not appearing. So now he is appearing and I'm trying to twist the issue.
If he doesn't
Not
want me to
adversarial
appear,
proceeding. I don't think, my lord, my learned friend should take this.
Probably the petitioner is right. The water logging is probably because of filling up of the khal. That's what And now to say,
my lord,
give a permanent solution, you remove the encroachment and whatever area has been filled up, you excavate it and form the channel.
I did not, I did not,
4 kilometers
I
stretch,
did-
my lord, everything will be.
I did not
eradicated.
wanted to my lord, waste my lord's valuable time, but PWD has stated on oath there was no khal. So I didn't wanted to, my lord,
All right, if there is no call,
But again,
then there will be a natural gradient. Water will always find its course.
my lord,
Hmm?
my lord,
Water will find its course. So if the course has been obliterated or obstructed
my lord.
by an encroacher, you have to first throw the encroacher
The
out.
encroachers will be certainly, my lord, within the time frame of the act. The encroachers will be taken care of. My lord, difficulty, my lord, will kindly, my lord, look at the difficulty. The encroachers will.
No, no, what the letter says, that is the page 9 of your annexure R2.
My lord,
You see that? There is a call exists, namely
Yes.
Bapuli Canal. The said so and so all other places and mentioned
Yes.
Paraso is not belonging to the irrigation department. Maybe
Yes.
whichever department it belongs, let them do
the
that.
PWD is saying it doesn't belong to me.
Very good. Then it is
That-
no man's land.
No, that is the reason, my lord. I did not, my lord, wanted my lords to dispose of the petition. Your lordship
No, no,
will
no. We want.
appreciate.
We will initiate prosecution.
My lord,
Lordship,
This fellow says it is irrigation department is not there.
no,
The other fellow says
what-
it is
what-
not a
what I
PWD
was-
canal.
This is being
what I-
done now, my lord,
And
is
who's in charge of
Lord,
this canal?
what I was humbly praying, my lord, will kindly appreciate
an
my
attempt has
prayers.
been made, my lord, to sark it upon the concerned
My lord-
panchayat.
My lord will
One
kindly
officer is
appreciate.
coming, one stand is being taken.
My lord will kindly appreciate.
Consistent stand from time to time.
My lord will kindly appreciate my prayers. I am praying, let the irrigation department chalk out a master plan immediately. Look, DM or PWD cannot
No,
do
no,
it.
this is washing off your hands. The
Well,
irrigation
I am not.
No, both of them say that there is a call in existence, but he says it doesn't belong to my department. To which department it belongs?
And that is the reason, my lord. That is the reason, my lord, what I am on. I am into solution.
Sir, master plan is drawn for the purpose of future implementation. What they seek in this writ petition is restoring status quo ante. What was the existence? Now you are facilitating or rewarding the encroachers. You are rewarding your clients by creating a master plan.
Yes.
And so that they can comfortably be there. 10-1, 10-2, 10-3 notice, another 5 years, the litigation go on, single bench writ petition, not to dispossess, give show cause notice, no opportunity personal hearing, another 5-7 years. They will sell the property, ground floor will become first floor, thatched building will become tiled building will become
Followed.
RCC building.
And unfortunately, that learned AGP who was appearing earlier, what stand he took, my learned friend is taking a different stand altogether.
Probably
Well,
he's been
he's-
instructed to. They don't take stands on their independence.
Yes.
It's
And
all
my lord,
based
kindly,
on
kindly,
instruction.
my lord, peruse this letter.
What is
What
that?
they are saying, it's a government's letter, my lord.
What is that letter?
Yes, my lord, this is request for providing land schedule acquired land for the purpose of construction of Muthurapur to Ghoradal PW road along with LA map.
See,
This
when
is
the
mentioned.
authorities don't deny that existence of call, the only problem is to which department it has been entrusted. You first let us, we'll issue a direction to the secretary. Why Home Affairs you have implemented?
Lordship, kindly direct them to serve me the
Yes, ma'am.
report, Lordship.
No. You
I'll file the exception, Lordship.
no,
Order
except-
says so.
We are not here to monitor your eviction process. You go and give your reply. You
Lordship,
give your
order,
Respond number 10, my lord.
Lordship, order in the order, it was Lordship directed the exception to the said report should be filed, Lordship.
We will recall that order.
Hmm.
Secretary Irrigation.
Lordship, then kindly make it not this week, Lordship. Mr. Hon'ble is appearing
No,
in
no.
this matter, Lordship.
All right, very good. Let him come. See, irrigation, there should be some other department which will say as to in which department this call vests. Irrigation says, this engineer says, it is not with me. PWD says it's not with him. Then with whom is the
These are the two departments, my lord, that should have, my lord, beared the burden.
the cost of the encroachers, my lord, the villagers are allowed to be submerged.
You come to page 11. What the block land and land reforms officer says.
My lord.
The middle of that, the Bapulur Kal. Read from that.
Yes. Bapulir Khal.
As mentioned in para 7,
My lord.
flows through plots behind Kali Mandir in the so and so. As per LR record, this Kal is a private in nature. That is Rayati Kal. The nearest plot in this so and so is more than 30 feet away. So compare with the RS map and the collector LA map. It is clear that the acquired land for the purpose of so and so road is not adjacent to the Kal, which is known as so and so. So everybody admits that it is. Then from where to where it is flowing, or
And in paragraph
This
7 of the
Milord,
read prison, I have
in my
stated that
humble
how the
reading, Milord,
Khal was there.
this Milord, he states it's a private land.
maybe even if it's a private car, conversion cannot be done without an application. Conversion cannot be done. It has to be maintained as a car. They will let him be a private owner. You get proper instruction in this. Ask some senior officers to come. You give her a copy of this report. In terms of the directions issued by this court on 4th April 2023, a supplementary report has been filed by the second respondent, copy of which has been furnished today to the learned advocate for the petitioner.
Okay, number
Copy shall also be furnished to the learned advocate for the proposed private respondents. Parties are at liberty to file their exception within 2 weeks from date. List the matter. June. Next.
Serial number 218.
I'm grateful, Milord.
Needless to state that effective steps be taken to effective steps be taken with regard to the eviction proceedings, which are already commenced by issuance of notices under section 10 within bracket 1, 10 within bracket 2, and 10 within bracket 3. The of the West Bengal Highways Act 1964. On the next hearing date, the status of the action taken by the department against the encroachers shall be placed before this court in the form of a report. This photo you give.
I'm grateful, Milord.
Next.
Milord, for item number 218, for item number 218, 219, and 220, I am for the petitioner. I have received change brief. I have no power with me at now because the petitioner is sick. So kindly allow a week's time so that I will be back with power. And what I have read, this thing, it is on the verge of disposal stage. So I have not much about to say. That's why I'm praying for a week's time for equipping power.
I am appearing for the 219 for state. I have submitted my report on all.
Yes. Now, what does he want? He wants some.
We have taken all steps, my lord. Lordship, can you see my report?
I do agree with him, and I have no power. That's why I have no power. Since I have no power, that's why I'm praying for power, and I will be back. Just give us an opportunity, then I will be.
All right. The learned advocate appearing for the petitioner submits that it's a change brief, and as on today, he does not have the power of attorney. Vakalatnama, and prays for time. The learned advocate appearing for the state submitted that report has already been filed and all action has been initiated against the alleged illegal activities pointed out by the petitioner. List the matter.
219 is concerned, my lord. I have appeared 219. 219.
219. It will be a common order.
Common order.
Put in July.
Serial number 221.
Better to appear on
July. Yes.
Lordship, the advocate for the petitioner, Mr. Kishore Mukherjee, had to leave court due to some personal difficulty. I pray to your Lordship for not today.
But I appear for the state respondents, my lord.
All India Anti-Corruption Organization.
Well, this is with regard to illegal sand mining. Well, the petitioners had filed this writ petition initially, challenging, my lord, questioning that one person has been carrying out illegal sand mining.
From which river?
My lord, this is sand mining in the river of Bhagirathi, my lord, subject to correction. My lord, thereafter, my lord, we filed a report in the form of affidavit in this matter. The private respondents were also represented. This honorable court was pleased to take into the consideration that affidavit, my lord. But the honorable court said, my lord, if your lordship kindly turns to the order dated 15th October 2020. 15th October 2020 in the writ petition. Well, the state has placed the report, though the petitions are confined to particular areas, it cannot be missed that illegal sand mining and removal of pebbles and boulders from riverbeds is a widespread malice all over the state, which could not have blossomed into such a massive industry that is at present without political patronage. From start, the mechanism has to be put in place to arrest the menace. The blame game and accusations can follow once the illegal practice has been stopped. It is possible that a broad-based special investigation team may be put in place by the court with the authority to monitor all rivers and like places in the state to stop illegal mining or the removal of any sand or boulder or pebble or the like from any riverbed. Several of the riverbeds, particularly of the Ajoy and Damodar in South Bengal, have been ravaged by illegal mining, and those responsible for protecting the state's assets have been looking the other way. The matters will appear for it to be dealt with more comprehensively a fortnight after the Puja vacation. In the meantime, the Director General of the State Police is requested to ensure that no kind of patronage or other consideration stands in the way of coming down heavily on persons who indulge in this illegal mining activity. Well,
now this broad-based special team.
It was no more required. My lord, if your lordship kindly sees the next order of 16th of March 2022. Sir, then, my lord, 16th of March, has your lordship got that? The next order. ওটা দেখাচ্ছি আমি বলে দিচ্ছি facts টা
16th of April we have got.
16th of March is there, my lord. There is one order. 2022. 2022. This is the next order. So it comes from backside, my lord. All the orders.
Yes.
Well, learned Advocate General has submitted that subsequent to the order dated 15th October 2020, state has framed the West Bengal Sand Mining Policy 2021, which provides for the revised framework to achieve the object of the policy mentioned in clause 5. He has also submitted the policy provides for the excavation, wing, storage, and sales wing and enforcement wing, and clause 8 thereof relates to monitoring activities. He has also submitted that the powers conferred by section 15 and section 23C of the Mines and Minerals Development Regulation Act 1957 rules have been framed by the state, namely West Bengal Sand Mining Transportation, Storage and Sale Rules 2021. He has submitted that these rules contained adequate provision relating to power to enter and inspect, power to seize, and also in respect of the prohibition on transportation, storage and sale of land. He seeks time to file report indicating if the district level sand committee and state level sand committee in pursuance of the rule have been set up and the authorized officer in place to take action in accordance with rule. Submission of learned Advocate General is that after framing of the policy and the rules, now there is no need for forming broad-based special.
What happened to this report?
My lord, that
report has not come, but I've taken instructions, my lord. I can, my lord, first is, my lord, the 2021 policy, my lord, has come into force. That's number one. My lord, I have a copy of the policy, my lord. Your lordships may look at that. Then, my lord, under that, my lord, give my copies. Just give my copies. My lord, under that, my lord, your lordship will find, my lord, that the West Bengal, my lord, WBMTDCL, my lord, was to, my lord, be, my lord, in charge, my lord, of, my lord, monitoring. The lordship will find that, my lord, in the policy framework, my lord, at page, my lord, what's been handed up to your lordship, my lord, clause 6, proposed new framework. My lord, 5 is the objectives of the policy. Page and copy.
Page 31.
Yes.
31, clause 6.
Yes.
Proposed new framework.
Yes. Your lordship will find, my lord, that this was done. Then, my lord, after that, my lord, um,
Already.
e-portal, my lord, has been launched. My lord, which, my lord, a central online portal to manage the entire life cycle of the mine. So, my lord, now we have e-challans, my lord, being generated online, replacing the old system of physical challan. Then, my lord, we had the rules, my lord. Kindly have a look at the rules, my lord, which were, my lord, on 25th January 2022. And, my lord, kindly come straight away to, my lord, Rule 17. Had a rules are copy. We have copies of the rules.
Now the state agency will start the mining.
Yes, now, yes, my lord, they will be in charge of monitoring it, my lord.
Monitoring.
Yes, this is in charge of monitoring and it will be the nodal agency, my lord, for this purpose. And my lord, there were two committees, my lord, which were to be set up. My lord, your lordships will find that, my lord, in my lord, clauses 9 and 10, my lord, there are references to it in Rule 17 and my lord, 18 and 19. My lord, question was, my lord, whether they had been set up. My lord, the notification, my lord, will happen in 10 days time. Your lordship, my lord, may note that because my lord, different, my lord, departments had to be consulted with regard to formation that has happened. And my lord, I had, my lord, inquired this morning and my lord, within 10 days time, notifications will be set up for the district level sand committee as well as the state level sand committee as provided.
That is the regulatory framework which you have put in place. But his allegation is against the 9th respondent.
Yes, 9th respondent had appeared, my lord, and we've affirmed an affidavit, my lord, that, my lord, he is, my lord, not mining in an area. And in fact, Mr. Somo Mojumdar was appearing, my lord, if I remember correctly, my lord, for the 9th respondent who had also, my lord, indicated that, my lord.
No action is no action.
No, my lord, they, as far as 9th respondent is concerned, my lord, allegations against him, my lord, we have given an affidavit that he is not mined beyond the area that was allotted to him. And instead, my lord, there were others who were caught and my lord, the penalty has been imposed and my lord, they have, my lord.
Those facts are on record.
On record. On record. In our reply, my lord, we filed an affidavit.
Then, see,
Lordship, for perusal of these rules, notifications and reports and affidavits, kindly grant a short adjournment for this matter. For the petitioner of item.
No, let this be notified, these two committees.
Yes.
Putting committees in place.
No, correct. There has to be, my lord, at the ground level, naturally, my lord. Naturally. My lord, that, my lord, has, my lord, in fact, my lord, I'll tell you, lordships, further steps have been taken, my lord. I have it, I took it down, my lord. My lord, while, my lord, traveling to court. And my lord, before I get derailed, my lord, I just wish to wish your lordship, my lord, congratulate your lordship, my lord.
Thank you.
My lord.
Wait, yes. No, what we'll do is you let them get instructions.
For only perusal of this report.
Let them peruse
affidavits, replies.
We have heard so and so. The learned advocate general had produced copies of the notification issued by the government of West Bengal, putting in place the West Bengal sand mining policy 2021 and the rules and the West Bengal West Bengal sand within bracket mining, transportation, storage and sale bracket close rules 2021. It is submitted that in terms of Rule 17, sub-rule 9 and 10, a district level sand committee and state level sand committee has to be constituted. And the learned advocate general has instructions to state that such committees will be constituted and notified within a period of about 10 days. Though it is a very laudable step taken by the state to form such committees, unless and until the committees take up the matter seriously at the ground level, effective implementation of the policy cannot take place. With regard to the allegation made by the petitioner against the 9th respondent, the department has filed an affidavit stating that the 9th respondent has not done mining activities over and above the permitted extent. let a further report be filed by the appropriate authority of the respondent as regards the formation of those two committees and as to how the committees will function to prevent illegal sand mining.
Functioning of the two committees.
List the matter. So on. July.
Matter
The only thing in the sand is
Lordship, matter to be listed on.
every time there's a tide or monsoon, it gets filled up.
Absolutely.
As a result of which, it's very, very difficult to, catch illegal sand mining. But it is not so with granite or
because it's, my lord, what is there? Yes.
what is excavated,
Yes,
there will be
yes,
a pit.
yes. Lordship's absolutely right, my lord.
I did one matter now in Supreme Court matter.
After Deepak Kumar's judgment due to pollution. Others of industries, commerce and enterprises.
Next.
My lord, may I make one request, my lord, to your lordships, my lord? Could the Department of Industry, Commerce and Enterprises, my lord, who actually are in charge of this, my lord, the government through the that particular secretariat, my lord, could they be, my lord, also made parties to these proceedings? Because
In
it's
order to issue further effective directions, the principal secretary, Department of
Industry, Commerce and Enterprises.
Industry, Commerce and Enterprises, Government of West Bengal, Kolkata is impleaded as the so-and-so respondent. The learned advocate for the petitioner is directed to make necessary correction in the cost statement.
Lordship.
Obliged, sir.
Serial number 224.
Grateful to your Lordship.
For the petitioner, my lord.
Yes.
My lord, in this
224, madam, I am for the private respondent. But you also can it take up tomorrow?
Tomorrow is not tomorrow's residuary.
Any day, any day. They have issued a show cause on the basis of that complaint. Show cause notice has been issued. I have been suspended. I am a fair price shop owner. Allegation against me that I have issued the ration card against the dead person, or that this thing that I have no nexus with the same. I have been so caused. I have been suspended, and now most probably the allegation is suspense is not sufficient. That is the issue.
My lord,
that's why I'm saying, my lord, tomorrow.
twice inquiry was held. Primarily, the inquiry report, court was very dissatisfied. Observation was made. Again, there was order. The district magistrate concerned was called in the court in the rule of contempt. Then, my lord, again, a fresh inquiry report was directed to be conducted. In that report, my lord, in the tenure of one district magistrate, it has been done. And it has been submitted in the court with the sign of different district magistrate, and it is admitted in the state affidavit. My lord, I have taken exception to that affidavit. I'm placing, my lord, the serious allegation is that, my lord, kindly see the observation
And
made.
who appears for the state?
Mr. Shishona Banerjee appeared. It's long pending matter since 2020, my lord.
Now, what do you want? He has been suspended. Some inquiry.
No, my lord. What? There was a specific direction of this honorable court that if the allegation of any misappropriation is found, state is a liberty without waiting for any inquiry to take appropriate criminal action against the private respondent.
They have not.
They have not done. Though they have found that 73, the ration dealer has been lifting rations in the name of 73 dead persons, and admitted, it is admitted in the report also, and selling it in the open market, my lord. And in the during the period of lockdown, my lord, the government has announced that free ration commodities should be distributed to the poor BPL card holders. My lord, that has not been done. Several entire allegations, and from the very inception, my lord, kindly find from the observations of the honorable court itself that the district authorities somehow is trying to shield the misdeeds of these private respondents. Well, kindly see from the order dated, I will indicate to the order dated 20th October 2021, my lord. 20th October 2020 and December 14, 2020. Other orders, my lord.
And you have filed an exception to the report of the third respondent.
Yes, yes.
What does the third respondent say in the report?
In the report, my lord, they say,
He is a very holy man.
no, they say that out of 73 dead persons, 42 family members of such dead person had not drawn ration commodities, but the rest 30 families have drawn ration from FPS dealer Amirul Islam Mondol. Our contention is that all those 73 ration cards are lying with the ration card holders. There is no scope for the families to draw ration. He is drawing ration in the name of those dead persons, selling it in the open market. Another second point, my lord,
It can be done without the thumb impression, without the biometric.
apart
Nowadays, it's a
from
biometric.
families, other numerous cardholders were also inquired. It was found
For dead
in
person
some
is-
cases the ration card holders are getting less commodities rather than their entitlement, but most of them are getting actual ration commodities allocated to them.
That's why I'll kindly fix it. next to
Thereafter,
any-
only for a eye wash, he was suspended. A fine of rupees 42,000 or something has been.
Oh, he should be removed from as a dealer.
Yes, my lord. Yes, my lord. And my lord, kindly say December 14.
No, that can't be done without conducting an inquiry. Reports have been filed. He is an aggrieved person.
Yes.
So we will direct action to be initiated. Let him be heard in the matter.
Action has been taken already.
A suspension as a punishment.
Yes, suspension is a punishment under the 2013 control order.
That is inadequate.
My lord?
That is inadequate.
No, my lord. That, according to them,
it is not proportionate.
According to the petitioner, it is not. It is inadequate. But the thing is
42,005.
that what
He
is the
deported,
allegation?
now
Is
continue.
that I have withdrawn the ration articles of 73% dead person. But so far the issuance of ration card of dead person and cancelling the same ration fair price shop has got no authority to the same. It is the duty of the.
No. The private respondent has been found guilty. Whether 42 cards, 4 cards, 6 cards, 1 card is not a criteria. This is meant for public distribution. So even if 1 kilo is missing, it's a serious matter.
Exactly so.
Okay.
Exactly.
So if 42 cards are there, dead persons cards have been utilized to draw the ration. It's a very serious matter.
That's why I have been punished with 42,000.
No,
once have been given punishment, they cannot give more another punishment.
So therefore, the court can examine whether the punishment was proportionate to the charge or proven charge.
Also, kindly sit up on Monday then. You need Monday. Can it sit up Monday?
Well, it is long pending matter.
Monday, I'm
Kindly
saying
see,
Monday.
There is a specific direction of this honorable court also.
Nobody appears for the state today.
I'll sit up on Monday. I will.
It has been categorically ordered.
Sri Sanya Bandobadya and Mr. Arka Nag Kumar Nag.
It has been.
You inform the state council Monday we will list it.
Well, kindly make it as a fixed matter, my lord.
Yes.
Monday.
We have heard the learned advocate for the petitioner and the learned advocate for the 8th respondent. Since the council representing the state is not available, list the matter on Monday in the daily list.
Great.
Serial number 225.
I'm late by Mr. Devudo sir.
With you.
For item number 225, your lordship, I am the petitioner in person.
Yes.
We are opposing this
Well, I am
application
for the
on
Eastern
behalf.
Railway Authority.
I'm for the Southeastern Railway Authorities. The application is should be summarily rejected.
Maintainable, no?
It's absolutely not maintainable. He has raised some hypothetical questions, private informations from us. We have given the reply through RTI.
No, we'll ask him. What is this rule 2.10?
Yes, that's a rule. That's a rule laid down in general rule of Indian Railways. That's a book name. Now the complaint was, Your Lordship, the matter was misappropriation of public fund in terms of payment of dress allowance according to the direction of 7th CBC. Now the matter is, Your Lordship, there is a unified SM cadre, the station masters cadres. They utilize and they are paid 10,000 rupees per year in every month, July, in their salary slip. That 10,000 rupees is incorporated for the wearing the dress. They have the specific dress in the during the sessional, like summer, winter, etc., and some others. In that one, Your Lordship, may I submit that a group of people, they call themselves TI, transportation inspectors, but they are the part of the unified SM cadre. What they are saying that we have no direction to wear the uniform, and they receive 10,000 rupees per year since it is from 2017.
Without wearing uniform, they are getting uniform allowance.
Yes, I'm coming to that point, Your Lordship. Please see the affidavit in opposition filed by Eastern Railway. Page number 5, paragraph number 14.
Yes.
Yes, Eastern Railway has submitted that with reference to the statement made in paragraph number 15 of the petition, I state that as per dress allowance by Railway Board circular number such and such dated such and such, station masters are entitled to get dress allowance to so traffic inspector stroke transportation inspectors, they are called as TI, are also paid dress allowance as the traffic inspectors fall under the unified.
Now, what to do with all these things? How are we to monitor?
Yes, that is the thing is that as amount has been misappropriated.
The rule provides for dress allowance for a particular category.
Yes.
It says that traffic inspectors and transportation inspectors fall under a unified category. One category, they have to wear uniform. Others, there is no compulsion to wear uniform.
No, it is there. It is there, Your Lordship. I'm coming to that point.
No, now you are saying that because those fellows need not wear prescribed uniform, why are you giving? That's a rule. It's a unified cadre.
No. I'm coming to that point, Your Lordship. Please see in the main petition, Your Lordship.
In your writ petition.
Yes, in the main writ petition.
Page.
Yes, page number 29. Page number 29.
Yes.
It is the information submitted by Eastern Railway itself. Now, Your Lordship, please see item number 3, Roman 4.
Yes, transportation traffic. Transportation traffic inspectors are authorized to wear prescribed uniform during duty.
Yes, but in that opposition, they have said that as they have no rule, it is in paragraph number 14 and 16. It is repeatedly stated that as there is no specific dress code for the traffic inspector to wear the uniform, so they are not wearing the uniform. Now there is a question, Lordship, if there is a uniform, then why they are not utilizing that? And if there is a uniform,
no, suppose if it is a unified cadre.
Yes. The question is about money.
See what they say. As per the dress allowance by Railway Board circular dated so and so.
Yes.
Station masters are entitled to get dress allowance. So traffic inspectors, transport inspector also paid dress allowance, as TIs fall under unified merged category of station masters, yard master.
Yes.
As there is no specific code for transportation inspectors, traffic inspectors, so and so, they are not wearing prescribed.
Yes.
So today a person may be a traffic inspector, and if he belongs to the merged category, he can become a yard master. He can become a station master.
Yes.
So once he goes a station master, he wears in white and white.
Yes.
So that cadre has been given.
But here, Your Lordship, it is clearly stated that the transportation inspectors are bound to wear the appropriate dress. That is there is a uniform. And now there is another information, Your Lordship. Please see page number Page number 31 in the main read petition. Item number E.
As they are authorized to wear uniform during duty hours.
Yes, that is my question, Your Lordship. Once the 10,000 rupees per year is paid to the specific cadre of the railway employees.
He is in a unified cadre, sir. You
Yes,
are
sir.
trying to truncate one cadre of traffic inspector, transport inspector out of the unified cadre. If it becomes interchangeable, then what?
But they are not doing that. You please see, Your Lordship, what they submitted, that we have no dress code, and here in the information they are saying that they have to wear the uniform. That is
There
the
is
question.
no way. Yeah, what is a illegal embezzlement and other, that all allegation, wild allegations. And he is a railway employee.
I am not a railway employee.
You are not a railway, and you are interested in railways.
Yes. But there are questions like
is there a railway museum in Kolkata?
Yes, in Howrah.
It is there.
Yes.
How you developed interest in railways?
Somehow.
You visited which is the oldest railway station in the country?
I think it's Vadivandar, Mumbai.
Mumbai. Here in Kolkata, West Bengal?
Probably Howrah. I'm not sure about that.
There is a organization in Chennai which consists of members who are all this train and railway lovers, and they conduct.
Yes.
You are a member of that?
Yes, I'm the member.
They'll organize a tour to the integral coach factory.
Yes. Perambur.
And in Korsiong, you have gone there to that workshop?
Yes.
Still the old British machines.
Yes.
Still what is that locomotive called? Fairy Queen or something? No.
Yes, Fairy Queen.
Fairy Queen. Still it is operational.
Still it's in operation.
Good. A better matter later. By this writ petition, the petitioner appearing in person alleges that uniform allowance is being given to the cadre of train inspectors and traffic inspectors who are not wearing uniform. In this regard, the petitioner would refer to certain information he has secured under the Right to Information Act, and would submit that the details furnished under the Right to Information Act are contrary to the averments set out by the respondents 1, 2, and 4 in the affidavit in opposition. It is submitted that in the said affidavit, more particularly in paragraph 14, it has been stated that traffic inspectors / transportation inspectors are not wearing prescribed uniform. Therefore, it is submitted that the uniform allowance should not be paid to those employees who are traffic inspectors / transportation inspectors, since they are not wearing uniform. This, according to the petitioner, has caused leakage of funds of the railway administration. However, what is important to note from the averments in para 14 of the affidavit in opposition is that dress allowance is paid as per Railway Board circular dated 3rd October 2017, and station masters are paid dress allowance, as also the traffic inspectors / transportation inspectors are also paid dress allowance, as traffic inspectors fall under the unified merged cadre of station masters / yard masters. And the reason they are not wearing uniform is there is no specific dress code for traffic inspectors / transportation inspectors as prescribed in RBE number 8 of 2009. Thus, we find that if there is a unified cadre or a merged cadre, And if there are opportunities for interchanging of the job profile, that is, a transportation inspector may become a yard master or even a station master, then that merged cadre has been considered as one unit and dress allowance has been paid. Therefore, we are not convinced to hold that there is any leakage of revenue merely because these traffic inspectors are not wearing uniform, because they form part of a merged cadre, and in respect of two other posts, there is a specific dress code. Therefore, we find there is nothing, there is no illegality as alleged by the writ petitioner. Accordingly, question.
Your Lordship, just one thing I have to add. In the affidavit in reply that I have submitted, please see in page number 9, there is a railway board circular, and it is clearly stated that the person who is sanctioned the dress allowance, if they will not wear the uniform, they will be facing the disciplinary action.
But correct. But suppose the RB or whatever railway board circular or order doesn't specify a uniform.
Yes.
That's the problem.
Then, Lordship, as only a prayer, your Lordship, please consider item number prayer item number B.
Needless to state that the railway administration should ensure that whichever cadre of post has been, ensure that if a cadre has been prescribed a dress code, the same should be scrupulously followed and adhered.
Yes.
Disposed of.
Serial number 226.
There is one.
Lord, I am appearing on behalf of the writ petitioner, Lord. The respondent number 6. Lord, the respondent number 6 is a headmaster in a primary school who appointed in 2003. And Lord, subsequently in 2018, the 3-tier panchayat election was held, and that headmaster contested the election. He win. And subsequently, Lord, he hold the post as Pradhan, which is full-time post. And Lord, without obtaining any permission from the school authority, the board, he is continuing with the 2 full-time posts.
He is receiving salary also.
My Lord. And my Lord, in the school, there are 70 or 80 students are depriving. Because my Lord,
he is sitting in the Pradhan office.
My Lord. And my Lord, the Panchayat Act section 8B is intended to debar a person to hold the 2 full-time posts. I have annexed that rule, my Lord, kindly have a look into page 16.
And he can't be holding an office of profit.
Yes, my Lord. This is also my point in the
prior
petition.
to proceeding with the matter, if I may just please the last order passed by this honorable.
What does it say?
Your Lordship, the learned counsel for the petitioner was granted 3 weeks' time to examine if such an issue can be raised in a public interest litigation or remedy lies in an election petition.
All right, that we will discharge him. You do one thing. You continue to teach, but we'll stop your salary.
Your Lordship kindly considers the allegation.
Either you be a Pradhan, be a guardian of public, and whatever it is.
I am protected by the statute, Your Lordship. The Pradhan is discharging his duties as a school teacher, and he has been permitted accordingly. The allegation that he hasn't sought any permission prior to contesting.
Lord, kindly have a look into page 18. I have annexed the act.
And without any support of document.
I have annexed the statute, my Lord. Kindly have a look into page 18 of my writ petition. Section 8, subsection B.
Subject to the provisions contained 94, person shall not be qualified member of Gram Panchayat if he is in service of the central or state government or a Gram Panchayat or Panchayat Samiti Zilla Parishad. It's hereby declared person in service of an undertaking so and so, so and so, so and so. Receiving aid from a government, undertaking body, directly or indirectly partner. Now, where is the permission which has been?
Lordship, I'll be replacing section 8B once again. Subject, I'll start from section 8.
Yes, directly or indirectly? No.
Lordship. Subject to the provisions contained in section 94 and 97, a person shall not be qualified to be a member of the Gram Panchayat if A, he is a member of any municipal authority constituted under any of the acts referred to in subsection 2 or subsection 1 of section 1, or B, he is in the service of central or state government or a Gram Panchayat or a Panchayat Samiti or a Zilla Parishad or a Mahukama Parishad of the council. And for the purposes of this clause,
Yes, the others may not be relevant. No?
Your Lordship, that will be relevant.
Okay.
And for the purposes of this clause, it is hereby declared that a person in the service of any undertaking of the central or the state government or any statutory body or corporation or any public or government company or any local authority or any cooperative society or any banking company or any university or any government sponsored institution or any educational or other institution or undertaking or body receiving any aid from the government by way of grant or otherwise, or a person not under the rule-making authority of central government, central or state government, or a person receiving any remuneration from any undertaking or body or organization or association of persons as the employee or being in the service of such undertaking or body or organization or association of persons out of funds provided or grants made or aids given by the central or the state government shall not be deemed to be in the service of the central or the state government. Your Lordship, the case is my client shall not be deemed to be in the service of the central or state government because he's a teacher in an educational institution, Your Lordship. His section is the statutory protection that I have.
The primary education board is the statutory body.
Milord,
which section B says?
Milord, may I assist, Milord? Milord,
He is drawing the salary
without
from the
supporting any of the parties, Milord, the allegation is that there is no permission taken. Permission taken from whom? The primary board, not a party. The allegation is the person teaches in a school and the school, not a party. The allegation is that if at all a fraud has been committed by a wrong affidavit while filing the nomination, the affidavit has been filed to the election commission, not a party.
Now, this institution, wherever he is teaching, is it an aided institution, private school?
Milord, it is, Milord, we do not know. In school, not before Milord's. Education department, not
primary school is a statutory body funded by government of West Bengal.
But then you have not made see before that. Should you not have written to the board, obtained information? So he says, as per this, if he is in an educational institution, this particular provision, he shall not be deemed to be in service of the central or state government. If that be so, what to do?
Milord
will kindly take up paragraph 8
first. He may be the employee of a statutory body. Primary school education is the statutory body.
No. He is not. Board is a regulatory body. It selects. It is a regulatory body. It will fix standards, saying that a school should have so many number of posts, etc., etc. A school comes up for recognition. They will consider what's the playground area, constructed area, how many classrooms are there, other facilities. They grant recognition. Then there is an order by the state government of West Bengal stating that mere grant of recognition will not ipso facto entitle you for aid. So there are a lot of recognized unaided institutions. Those will not fall within the state.
Yes, Milord, the Primary School Education Act says now I did not brought to this, Milord. This is the government organization, finance, control and managed by the state of West Bengal. Milord, I will produce the statute. Milord,
two documents.
Primary
One
education
is paragraph 8. Milord, paragraph 8, if Milord allows me, I will place Milord. It says that your petitioner submits that at the time of contest in the election, the respondent number 6 did not seek permission from the district primary school council Purba Bardhaman, since he is serving as a primary teacher under the primary school council, which is running under the direct financial help of the state government. So, Milord, two important parts. First, he knows exactly who is to be made a party. Second, he also knows the school runs is run by the help of the government. It is not a government school. With the help of the government. Now, Milord will kindly take up
what help we don't know.
Aid, perhaps.
No, we don't know.
No, Milord, it is not before. Milord will kindly take up
page 22. Not automatic here.
My lord, the primary education is not running with the aid of the government. My lord, it is directly the organization of the state government. My lord,
The inadequate.
and my lord, in my writ petition, my lord, the disqualification proceedings to be initiated by the sub-divisional officer who is made party here.
You go before him, you submit a petition. If you are challenging his election,
My lord, I have made a representation to the sub-divisional officer.
pursue that representation.
Milord, perhaps, Milord, if an election is challenged, Milord, perhaps that will not be the procedure, Milord. Let him take steps in accordance with law to challenge the election,
This
Milord.
petition styled as a public interest litigation.
If is at all
The
entitled.
petitioner who contend that the sixth respondent is disqualified from holding the post of Pradhan. Of which Pradhan?
কোথাকার প্রধান বলো?
Amarun number 1. Amarun 1 gram.
Amarun number 1 gram.
Amarun 1 gram.
On the ground that he is employed as a teacher in a primary school. As rightly pointed out by the learned advocate for the respondent state. Head teacher. Rightly pointed out by the learned advocate for the state. The pleadings in the writ petitioner are inadequate and the proper and necessary parties have not been implemented. It prima facie appears that there is an indirect challenge to the election of the sixth respondent as Pradhan of the Gram Panchayat, which cannot be permitted by way of a public interest litigation. That apart, from the averments in paragraph 8 of the writ petition, we find that it's not clear as to whether the school where the sixth respondent is a head teacher is a government aided school or a government school or a school or is a management school is or a self-financed management school. In any event, with these truncated pleadings, relief sought for cannot be granted. Therefore, the prayer in the writ petition is rejected. However, this will not prevent the petitioner from pursuing his representation before the district magistrate, Purva Bardhaman, the second respondent herein, and the petitioner is also given liberty to submit a fresh representation with proper facts. And if done so, the second respondent shall consider the same in accordance with law. Next.
Lord, within a certain period, Milord, because the Panchayat election is
cannot be
going to
challenged
be
like
declared
this.
after 2 months.
Elections were
This
to be
is the
challenged, they were
election
to be
petition.
challenged within a
Milord,
period of
election
1 year,
petition.
Your
You
Lordship.
missed out on election petition. This route here.
And Milord, election petition that too 1 year from the election. We are with the tenure is over.
Everything is over.
Oblige, Milord.
Serial number 227.
227.
I'm for the petition.
And as per the previous order of this honorable court, I am filing this report, my lord.
My lord, I want to give exception to the report, my lord. Kindly.
Not required. What is the matter you tell?
Matter, my lord. Yes, my lord. Matter is, my lord, that I have alleged that there is a drain, my lord. There is a drain, my lord. There is a kacha drain, my lord. Before in our area, through which, my lord, the water is flows, my lord. My lord, what happened, my lord? The Kandi municipality has started, my lord, constructing the Pakka drain, my lord. But suddenly they stopped, and now, my lord, within this stop, my lord, one, my lord, Sopon Mondol, my lord, private respondent, they have constructed over the drain, my lord, obstructing this, my lord. So this caused, my lord, the blockage of this, my lord, drainage of water, my lord, and the persons from the locality has, my lord, having problem, my lord. In a exception, in a report, my lord, they have also, my lord, supported that they have started constructing the drain, my lord. That, my lord, kindly see, my lord. My lord, kindly come to, my lord.
But
your five.
Petitioner and his wife appear to be very powerful persons.
No, my lord.
Chairman of the municipality,
No,
vice
no.
chairman of the municipality.
No, I am not the chairman.
No, you see the reports, para 4, page 2.
But I was the ex-councillor of the at that area.
He was the petitioner's wife,
Wife.
namely Santana Roy, who is also an assistant teacher of a primary school, councillor, member of board of councillors of Kandi municipality from 15 to 20. Wife of the writ petitioner was also vice chairman, later acting chairman from 2016 to 2018. They're raising the voice. Oh, no.
It's a
This
it's
is
a political interest litigation.
mischief litigation.
Well, kindly see
And
paragraph
not
5.
only that, my lord.
She can construct and give.
Yes.
No, my lord, if
All right, we will discharge them. What happened to the drain?
yes, my lord, I want my lord the drain be constructed.
My lord, may I
So kindly go through paragraph 5 once, my lord.
Yes.
Of that report, my lord.
Yes.
Kindly go through, my lord. May I read?
Conducive drainage. It's construct a pakka drain, but not necessarily urgent basis. It is decided to construct a pakka drain on the side of the road. Said decision was taken to facilitate. First process was started, e-tendering.
Yes.
Work order issued to
Yes, my lord.
Yasuddin Ahmad. Started to cut down the earth. Construct immediately to confirm plots upon which drain was constructed belong to government property. Work was stopped. Also, our telephone request not to proceed further. Consent for the appropriate government.
So kindly see the action, my lord.
One Sapan Mandal open drain. It's not true.
Well, kindly consider, my lord, the municipality has already tendered. They have, after giving tender, they thought that this is a.
This Sopan Mandal,
Yes, my lord.
this construction was available when your client's wife was the councillor. She only granted permission.
No, that is that they can show, my lord. They have not given
By
any.
this public
And my lord,
investigation,
my lord, may I?
Kindly,
petitioner seeks for direction upon the
kindly-
respondents to construct
kindly consider the drain, my lord.
a
That
drain.
direction will be given.
The report submitted by the third respondent in the form of an affidavit raises a very crucial issue regarding the petitioner's locus standi, his bona fide, and the maintainability of the writ petition. The petitioner appears to be a very powerful person in the area, as his wife, Santana, Santana Roy, who was an assistant teacher of the primary school, was also a councillor member of the board of councillor of Kandi municipality, and she was also the vice chairman, and she was also acting as a chairman. The allegation of the petitioner is that one Sopan Mandal had put up some construction and the report states that the construction is not a new construction but was in existence when the writ petitioner's wife was the councillor and vice chairman. In any event, all these issues will clearly disentitle the petitioner from approaching this court as a public interest litigant. We would have been well justified in dismissing the writ petition with exemplary cost, but we do not propose to do so, since noting the averments in paragraph 5 of the report filed by the third respondent, where steps have already been taken to construct the pakka drain, but however, the appropriate authority could not proceed because the property was found to be a government land. Therefore, we direct the concerned chairman of the municipality to take appropriate steps for obtaining approval from the government and examine the feasibility and proceed to implement, proceed to consider the pakka drain so that the public will be benefited.
My lord, only if the state can give permission.
Yes, after obtaining. The writ petition is dismissed with the above observation.
Dispose of, my lord.
Disposed of. That's all.
My lord, report will be kept on record.
Report record. Your report only we have referred.
I'm grateful, my lord. Stop.